reconstruction format for ARCA, correct?
That is correct.
What sort of contracts does ARCA routinely engage in?
So we do a lot of work in civil litigation. So we work with insurance carriers, law firms, but we also consult with and do projects with the federal government, as well as the National Hockey League on player safety. So we're involved in a number of research projects as well.
Is there other clientele that seeks out ARCA for accident reconstruction or biomechanics or human factors issues?
In terms of beyond the parties that I just listed?
You mentioned the U.S. Department of Defense.
Yes, the military, yes, the Army.
Tell me a little bit about the work that you've done for the Department of Defense.
Well, that was before my time, but I'm aware of projects that dealt with working on vehicles that were over in the Middle East, where they basically designed energy-absorbing seats because there was injuries when the vehicles were going over IEDs.
Is ARCA known both nationally and internationally? Is it recognized as a leader in accident reconstruction issues?
Yes.
As the director of accident reconstruction at ARCA, do you specialize in both accident reconstruction and the human factors that are associated with such reconstruction where necessary?
Yes.
Can you give me a synopsis of the professional discipline of what is accident reconstruction?
I think a simple definition in my mind would be the application of physics, engineering science, and mathematics to collision events. I always like to think of it as if you open up the puzzle box and you dump the pieces out and you've got a bunch of pieces and you're trying to piece together the evidence to see how everything fits to get a clear picture.
And what is the application of human factors to that process?
So to give you an example of human factors in the field of accident reconstruction, so I do a lot of nighttime visibility and conspicuity work. So to give you an example of that, let's say a driver's driving down the road at night, there's a pedestrian that's crossing the road. So we want to have an understanding based upon that pedestrian's clothing, the headlights of the vehicle, any potential artificial lighting in the area. When does a driver recognize that individual on the roadway? And then we can also look at literature to have an understanding of how do drivers respond based upon the hazard they're presented with. So there's different response times depending on the hazard. So it's going to be different for a pedestrian crossing the roadway or a driver responding to a vehicle suddenly stopping in front of them.
Dr. Wolf, as an accident reconstructionist, do you investigate and reconstruct both passenger vehicle issues, commercial vehicle issues, motor vehicle, pedestrian issues, all of the above?
Yes, I see all types of accidents.
And how long have you been doing this work with ARCA?
A little over 7 years now.
What education, training, and background qualifies you to perform the duties that you've just described for the jury?
Back in 2012, I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses while at JMU included courses in physics, statics, dynamics, kinematics, material science, along with your other engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
What additional training or experience do you have as it relates to accident reconstruction in addition to the formal education and the PhD?
Certainly. So in addition to my undergraduate degree and my PhD, I've continued to take courses through Northwestern University in crash reconstruction. So those courses have included human factors, lighting. I've taken courses on electronic vehicle data, photogrammetry, three-dimensional laser scanning. So I've continued to take courses subsequent to graduating.
Do you also hold any accreditations in terms of accident reconstruction?
Yes, I'm accredited by an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstruction.
Are you trained in photogrammetry?
Yes, sir.
Is that to determine vehicle crash incidents or the circumstances surrounding them based on map scenes, evidence from photographs, things of that nature?
Absolutely. So photogrammetry is the science of extracting information, if you will, out of photographs. So things dimensionally about an object spatially without ever actually physically seeing the object or inspecting it.
So you don't have to be at the scene to effectively and scientifically reconstruct it to your satisfaction?
No, not at all. And quite frankly, to be honest with you, in my world in civil litigation, oftentimes by the time a case comes across my desk, it's, the accident happened 5 years ago. Some I've even had 10 or 15 years ago. So getting access to the vehicle at that point, it's going to be a long shot.
Doctor, are you a member of any professional societies?
Yes.
Describe those, please.
So I'm a member of the Society of Automotive Engineers, SAE. I'm also a member of the National Association for Professional Accident Reconstructionists, the Optical Society of America, and also the Illuminating Engineering Society.
How many cases would you say in your experience in your career have you reconstructed or attempted to reconstruct, you or your team members?
I don't actively track that. If I had to estimate at this point in my career, it'd probably be well over 1,000.
And how many of those 1,000, I know you'd have a number specific, but how many of those 1,000 would you say involve pedestrians as well?
But several hundred. As I mentioned earlier, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
You've done testing or research as it relates to the kinematics and the interaction between pedestrians and vehicles.
Absolutely. So we do a number of tests at ARCA to look at the interaction between pedestrians and vehicles. One of the ones I know I did most recently where we were evaluating a vehicle essentially rolling over a pedestrian. So we wanted to understand the vehicle dynamics as well as the interaction between the pedestrian and the road surface. So we conducted testing at ARCA to evaluate that.
Does ARCA have any other disciplines other than just accident reconstruction?
Absolutely. So as I mentioned earlier, we have crash worthiness. So again, that's where you're going to be looking at the safety of a vehicle. How does it perform in a crash? We have human factors, failure analysis, premise liability, and biomechanics.
As an accident reconstructionist, doctor, do you or have you studied or tested the forces that are at play between objects interacting, a human being interacting with a vehicle, for instance?
Yeah,
That's
absolutely.
part of what you do.
Yes, sir.
Describe that.
So we use hybrid instrumented dummies at ARCA for our testing. So if we want to have an understanding that an occupant in a vehicle, the forces that they might experience, or for any matter, again, if it's an instance where you have something that ends up falling on someone's head and you want to have an understanding of the forces involved in that, we perform testing with hybrid dummies.
Have you ever authored any peer-reviewed papers in the field of physics?
Yes, sir.
Describe those for me.
So I have a number of papers in the field of lighting and optics. I have a recent publication that deals with Toyota and Lexus vehicle control history records as well.
Is that called Toyota Vehicle Control History, Sudden Braking History Recording Characteristics?
Yes, sir.
All right. Was that specific to dealing with vehicles and their interaction with other vehicles and or pedestrians?
It involved looking at the various triggers that system is capable of recording. And specifically, it was looking at what triggers a sudden braking event. So we were able to determine that those triggers, the sudden braking event is triggered when a driver, or I should say the vehicle,
Jackson,
reaches.
may we approach?
Sure.
You are unmuted.
Now you're.
Yes, you can
Thank
move
you.
on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction. Is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Unetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense. Is that right?
Correct.
And not connected in any way to the Commonwealth. Is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustain, Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You'd never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides.
In terms of them reaching out?
Correct.
Yes,
And I called you ultimately after receiving your report, asked if you'd join us and testify, correct?
that is correct.
Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case, as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe.
And what was your focus? If he's talking about the injuries to Mr. O'Keefe, what was your focus in your reconstruction and your analysis?
I would simply say it was looking more at the damage to the vehicle.
Okay, so in terms of your team and the responsibilities of each of the team members, you were more focused on the damage to the SUV. Dr. Rentschler was more focused on the injuries suffered by Mr. O'Keefe, correct?
I think that's a fair characterization, although with the caveat that we worked together as a team. So we weren't isolated kind of in those areas, not speaking to each other. We certainly worked together on the analysis.
Understood. Were you provided or did you review certain materials in furtherance of your consultation in this matter?
Yes.
What were you provided?
We were provided photographs of the incident location. We were provided photographs of the Lexus. There were a couple of incident reports that we received. I could look at my report for the full list, but those are the ones.
You can go ahead and do that, Doctor.
Do you have the report with you?
Yes, sir.
I have a copy of it. Is this faster?
Sure. If you.
May I?
Sure.
Thank you.
How many categories of materials were you provided?
Provided, it would be approximately 10.
Could you list those off for the jurors, please?
It would be the Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus 570, report of autopsy, and autopsy photographs.
Based on these data that you were provided, were you able to satisfactorily, to your mind, satisfactorily engage in the consultation that you were hired to do?
Yes.
And come up with some opinions and conclusions based on scientific certainty?
Yes.
Did you review scene photographs of the alleged incident?
Yes, sir.
What information were you able to glean or gather from your review of the photographs, from the scene specifically?
So from those photographs, I was able to identify there was fragments of transparent, red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at scene, maybe a leaf blower?
Correct. It appeared to be daytime, yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically, when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots and then you step into a specific piece of evidence so that you can, at a later point in time, identify where that evidence is. I noted that in a lot of these photographs, I didn't see a whole lot of that stepping in. It was essentially just zoomed right into where that evidence is, but not really having a great understanding of where was it relative to all of the other evidence.
Or when it got there?
Correct.
Based on your review of all the materials that you described for the court, did you get an understanding of what the Commonwealth's theory of the case is, specifically Mr. O'Keefe was struck by the Lexus SUV?
Objection.
Sustained.
Did you come to understand that the allegations before the court were that Mr. O'Keefe was struck by the vehicle?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Did you perform an accident reconstruction specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe?
Yes, I think that's a fair characterization.
And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle?
Yes.
Okay. During your analysis, did you note the damage to the vehicle?
Yes, sir.
Describe that, please.
So the primary damage was to the right taillight. It appeared to be fractured with the majority of the lens cover, so that clear and red plastic covering missing from it. In addition to that, if you're looking at the back of the vehicle, to the left of that, in the area above there's also another tail lamp assembly on the lift gate. So above that assembly, there was a small dent along with some paint chips on the bumper, more so on the wraparound section as it kind of curves around to the right side of the vehicle. There appeared to be some superficial scratches as well in that area.
Was there any other damage or deformation that you were able to glean from your review, the photogrammetry, damage to the Lexus, the bumpers, the panels, the quarter panel, the sheet metal, anything like that?
No, the rest was remarkably intact.
Is it common in vehicle pedestrian collisions that there's some sort of bumper displacement and or sheet metal deformation that's concomitant to that?
Absolutely. Assuming a pedestrian is positioned in a normal upright position, you certainly would expect to see damage to the bumper. In a lot of cases, what happens is, the bumper is just clipped on. So again, the force of that impact will oftentimes cause the bumper to kind of become unmounted or unclipped. You certainly could see deformation to body paneling, such as the lift gate or the quarter panel as well.
Is that especially true at higher speeds, meaning above 15 miles per hour or so?
Oh, absolutely. Yes.
Was there any apparent damage to the Lexus that appeared consistent with any kind of pedestrian interaction that you saw?
No, it was really confined to just the taillight, a very isolated portion of the vehicle.
During your review and your investigation, did you note information concerning items that were supposedly found on the bumper?
Yes.
What was that?
I believe it was noted there was 2 apparent glass fragments located on the top bumper cover.
What's the significance of the presence of those items or the lack of materiality of those items in your view?
Well, again, I think it's going back to the scene evidence. Again, we knew that there was glass fragments, what appeared to be from a drinking glass at the scene of the alleged incident.
Is there any glass consistent with the glass that was supposedly found on the bumper in the taillight housing, the taillight mechanism, anything from the car, from the Lexus that would account for that glass?
Okay, I think I understand. So the taillight itself is not comprised of any glass. It is all plastic. So that damage, or I should say that glass on the top bumper cover could not have come from the right taillight.
Now, based on your review of the information that was provided to you, did you undertake any testing of that vehicle? I'm sorry, any testing concerning the damage to the vehicle?
Yes, sir.
All right, can you describe what that testing was?
So we performed, again, this is with Dr. Rentschler and I working together on this again. We performed projectile testing to the tail lamp with a drinking glass as well as a hybrid head form.
Let's take those one at a time. How would you describe the drinking glass test?
Certainly. So again, from our review of the evidence, we knew that we had an isolated portion of damage to Lexus confined to the taillight. So we know that we're dealing with potentially a small object that could have created that. Looking at, again, the evidence in terms of the scene photographs, we know that we have a damaged drinking glass at the scene in the vicinity of the fragments of the taillight. So the theory that Dr. Rentschler and I put forward is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture.
I'm going to interrupt you right there. You and Dr. Rentschler formed that theory and wanted to test that theory, correct?
Yes.
You were not told that theory by the defense because you've never met us?
Correct.
You were not told that theory by the Commonwealth. You've never met them, correct?
Correct.
Your theory was the product of simply having some facts extant in the data, that a broken drinking glass, a broken taillight, let's put them together and figure out if the drinking glass could be responsible for the taillight, vice versa.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this, let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay. As a matter of fact, and importantly, while you were doing your testing, had you ever even heard of the Karen Reed case?
No.
So getting back to that testing, and I interrupted your flow, you were looking at whether or not the glass could have produced the damage to the rear taillight that you saw, correct?
Correct.
And what did you do in furtherance of making a determination about whether or not that was possible?
Certainly. So myself and one of our lab technicians at ARCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So it essentially, you can think of it kind of as a giant cannon, but it had a barrel, and then there was a valve that would open rapidly, and directly behind that was a pressurized vessel. And depending on the pressure, the PSI of that vessel would determine essentially the speed at which that glass would be projected into the taillight.
So you literally built a cannon?
Yeah, it's pretty awesome.
Pretty cool job. Tell me what the results of your testing was with this pneumatic cannon that would fire the drinking glass.
Certainly. So we performed 2 different tests in terms of speeds. The target speeds were 30 and 40 miles per hour.
Why was that?
Well, so with consultation with Dr. Rentschler, he indicated that is a reasonable speed at which an adult male or an individual, for that matter, could throw a drinking glass at the taillight.
Had anybody up to that point, told you any specific, let's see if I can rephrase that. Had anybody indicated that there was any evidence whatsoever that John O'Keefe had thrown a drinking glass at the taillight?
No.
Was this another example of you and Dr. Rentschler and your team just exploring sort of every possibility and working a little bit in the blind.
Objection.
Sustained.
What was the reason that you decided, or you and your team decided, that you wanted to approximate how a grown man could throw a glass in a taillight?
Well, I think we wanted to have an understanding is when a projectile such as a drinking glass interacted with the taillight, would we get damage on the test taillight that was consistent with that of the subject taillight?
Understood. So based on your theory, were you able to approximate the damage on the taillight?
Yes.
Describe that for us.
So as I mentioned, we ran two tests. The target speeds were at 30 and 40 miles per hour. And there was a little bit of variability in terms of what our target was and what we actually achieved. So the achieved speeds were at 31 miles per hour and 37 miles per hour. So there's just depending on how the glass leaves the barrel and some of the rotation can affect some of the speed, or ultimately the end result speed to that. So what I will say, though, is that with the 37 mile per hour projectile into the taillight, we noted and observed that there was damage that was consistent with that of the subject tail lamp, and that the test tail lamp had the majority of the outer lens fractured and missing, broken into pieces, as well as some underlying damage to some of the internal components as well.
Are you saying, well, let me ask you a different question. You were able to replicate the damage to the taillight using a pneumatic cannon firing a glass at 37 miles an hour directly at the taillight, correct?
Correct.
All right. And that would also shatter the glass too, correct?
Correct.
Did you do any testing about whether or not that damage to the taillight could be produced by a person simply holding a glass and being hit by the car driving in reverse?
We didn't do any testing of that, and primarily because, again, if we're looking at the arm and its total length, right? We only have a narrow damage pattern, which on the taillight, if you think about where where it meets the lift gate into where it starts to wrap around to the side of the vehicle, it's only about 6.5 inches in width.
All right. When you fired the glass into the taillight was static. In other words, it was not going to move. It was immovable at that point, correct?
Correct.
All right. So the glass is hurling through the air at 37 miles an hour and hits the static object that's resisting. And that smash is what produced ultimately the taillight damage that you were able to replicate. Is that right?
Yes.
If a person were holding in his hand the glass and the taillight were to hit that hand, the hand would not remain static, correct?
Objection.
Sustained. Ask it differently, Mr. Jackson.
If the taillight were the taillight would make contact with a person holding the glass, would that replicate what you did in terms of you're firing a glass into the taillight? In other words, are they apples and apples?
No, I don't think it would be the same.
Okay. Why is that?
Well, as I mentioned earlier, again, the damage to the back of the Lexus, again, is confined to just that roughly, again, when we're talking about the taillight itself, that 6.5 inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr. Rentschler, inconsistent with the injuries to the arm.
So given everything in your investigation has revealed concerning this testing, are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection.
Sustained.
In all the information that you provided, you were not provided anything that suggested that John O'Keefe threw a glass at the taillight. Right?
Objection.
Sustained.
Fair approach.
Yes.
You are unmuted.
May I? Yes. Thank you. What information, if any, were you provided that suggested that John O'Keefe threw a glass at the taillight?
No information.
What information, if any, were you provided that suggested that John O'Keefe may have had a pneumatic cannon with him? Is that right?
I'm not aware of any information regarding that.
All right. You also did some testing concerning a drop test. Is that right?
Correct.
Tell us about that drop testing.
Certainly. So again, through discussion with Dr. Rentschler, it was my understanding that Mr. O'Keefe had a skull fracture on the back of his head. So we wanted to do an evaluation of the interaction between the back of a head. In this case, we used again, talking about that instrumented dummy again, we used the instrumented hybrid head form to perform a drop test to evaluate the forces of an interaction between a tail light from the Lexus and the human head.
What height did you choose to perform this drop test?
7.5 feet.
Why did you choose that height?
Well, if you calculate it through physics and the acceleration due to gravity, that would equate to an impact speed of 15 miles per hour at that height.
And what was the significance of 15 miles per hour?
Well, that was essentially kind of a starting point for us, if you will. So I will tell you that in reverse, 15 miles an hour is fast. I don't know if you've ever looked at your speedometer when you're pulling into your driveway, reversing into it, into a parking stall. Most people probably don't go more than 5 miles an hour or so. So 15 miles an hour in reverse is fast, especially when we're talking about, it's my understanding it was nighttime. There was winter conditions, potentially wet or icy roads. So again, that speed is going to be what I would say on the high end for going in reverse. So also in addition to with respect to kind of just the nature of that speed, it's my understanding through discussion with Dr. Rentschler that at 15 miles an hour, you start to see significant injuries to the human body when it makes contact with a vehicle. And I think one last point is that we needed to pick a speed where, again, this is kind of just us brainstorming, where we would have damage to the taillight, right? It would fracture it, but it wouldn't completely obliterate it. So we knew if we chose a speed, for instance, of 40 miles an hour, we know we're going to completely essentially explode the taillight. But if we do, 1 mile an hour, we may not do anything to it, right? So we kind of had to pick a middle ground to again, cause damage to the taillight.
What was your conclusion with following that testing? What was your conclusion with regard to whether or not it was consistent or inconsistent with the damage to the truck? The taillight was consistent or inconsistent with making contact with John O'Keefe's head at or above 15 miles an hour? So
strictly speaking to a damage perspective, the 15 mile an hour interaction between the hybrid head form and the test tail lamp produced significantly more damage than that of the subject vehicle. So that indicates that, again, the damage on the subject tail light was less than that of the test tail light.
So if I were to ask you whether or not there would be more or less damage to the tail light if you increase the speed to 24 miles an hour, what's your conclusion?
Well, you're talking about significantly more kinetic energy. So if you just think about it from, again, a kinetic energy standpoint, kinetic energy is equal to 1/2 times the mass and the velocity squared. So if you're squaring that velocity and you're going from 15 up to 24 miles per hour, you're going to get a significant amount of more energy associated with that. Probably, I could pull up my calculator, but you're probably looking at 2.5 more times energy than the 15 mile an hour test.
Which means 2.5 more times the damage to the taillight?
Certainly.
Which you did not see in your review of the materials, correct?
Correct.
So what is your opinion or conclusion as to whether or not the damage to the taillight was caused by striking John O'Keefe's head?
From a damage standpoint, it was inconsistent.
I want to shift gears back to the injuries that you saw concerning Mr. O'Keefe's arm, his right arm. During the course of your investigation, did you look at photographs and investigate the injuries to his right arm?
Yes, sir.
What's the width of the taillight, specifically from where it meets the lift gate to the left side? I'm sorry, to the side of the vehicle, the right side of the vehicle.
To the right. So yeah, as I mentioned earlier, that is about 6.5 inches. It starts to wrap around to the right side. So really it's, even though the taillight continues, it's not projecting out on the back end where it's again wrapping around. So in terms of the width that is facing the rear, if you will, it's about 6.5 inches.
And you noted that there was a dent and some paint chips that you identified above the lift gate, correct?
Correct.
How far away from the right side of the vehicle were those scratches and that dent?
Approximately 20 inches.
What was the significance of that distance?
Well, again, to go back to your question about, I think if somebody was holding a drinking glass, right, and their arm was extended to cause that damage, or if it's theorized that those dents and chips were from that. Again, the thing that sticks out to me is that you have essentially the Lexus taillight.
So ask another question.
What's the significance of whether or not there was damage between the dent and the taillight? In other words, that 20-inch area. Was it dented? Was it harmed in any way?
So in terms of, again, if we're talking about, again, looking at the back of the vehicle and we go to kind of where that right tail lamp just meets the lift gate, as I mentioned, there's another lamp assembly on the lift gate itself. There's also a chrome trim piece above that, and then certainly the body paneling to the lift gate itself. And I think what stood out to me is that between that dent and the fractured taillight, there was no observable damage to that area, which I would have expected had an arm been positioned there.
Can you calculate, or could you calculate, or did you calculate the amount of force that would be required to strike a person just only on the outstretched portion of his arm in order to project him a number of feet, for instance, 30 feet in one direction or another.
Okay, I just want to make sure. Objection.
Take a distance out of it. Break it down.
I'll ask you the same question, but without the 30 feet.
Okay.
Were you able to calculate, or could you calculate the force that would be required to strike a person on his outstretched arm hard enough to spin him around and project him a number of feet?
If you're talking about only an interaction between the arm and the back of the vehicle, no, there wouldn't be any projection. Again, if you think about this, the arm weighs about, again, with Mr. O'Keefe would be about 11 pounds. So you still have, another 200 plus pounds being held down by gravity, and the force is only acting on the arm. So essentially the arm would be accelerated, but the whole body, because the center of mass is not being struck, would not be projected.
Is the absence of the damage that you described, the absence of damage that you described between the dent and the rest of the vehicle, with the exception of the taillight, is that consistent or inconsistent with striking an outstretched arm of a human being?
Objection.
I'll allow that.
That would be inconsistent, in my opinion.
Yeah, just a moment, Your Honor.
Yes.
And what is your opinion, Doctor, as to the amount of damage that you would expect to see at 15 miles per hour or above on the taillight, if in fact that vehicle were moving in reverse and were to strike something on a human body, for instance, an elbow or an arm?
Objection.
I'll allow
I'm sorry, can you repeat the question?
Probably not.
Sorry.
I'm trying. Physics, that's what. From your testing, what would you expect to see in terms of the damage to the right rear taillight, if in fact that taillight were to make contact with a part of a human body, for instance, an elbow or an arm, at 15 miles an hour or above? What would the level of damage be as compared to the damage that you actually saw?
Well, if we compare it to, again, looking at the drop test that we did with the hybrid head, which weighs about 10 pounds. So again, if we're talking about now a human arm that's comparable in that same weight, we certainly would expect to see a comparable level of force and damage. So as I mentioned, if the arm is outstretched across the right tail lamp and into the liftgate section, I would certainly expect to see deformation to that body paneling, even potentially the tail light on the liftgate itself and that chrome piece as well.
Based on the entirety of your investigation, your entire team's investigation, all the testing that you did, all the biomechanical testing and the engineering and the physics testing that you did, in your expert opinion, was that taillight damaged by striking John O'Keefe on the head?
Objection.
Sustained.
In your opinion, was the taillight damaged by either striking Mr. O'Keefe on the head or the arm?
Objection.
Sustained.
Any reproach?
Yes.
You are muted. You are unmuted.
May I, Your Honor?
Yes.
Last question, Doctor. In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you. That's all I have.
All right, jurors, we will take our morning recess.
All right, report, please.
You are muted.
Call me, please.
Orders in session.
Right, Mr. Lally, whenever you're ready.
Morning, sir.
Good morning.
Now, you in conjunction with, Dr. Wenchler, is that correct?
Dr. Rentschler, yes.
So you in conjunction with Dr.
Keep your voice up, Mr. Lally.
Yes, you in conjunction with Dr. Rentschler and Dr. Klein wrote a report in regard to your analysis, correct?
Correct.
And doctor, that report was issued on February 12th, 2024, is that correct?
Correct.
And in the first paragraph of that report, the last two sentences, you or whoever the author of that particular portion indicates, this analysis is based on information currently available to ARCA and is only to be issued in its entirety. However, ARCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
Correct.
And that's pretty standard as far as your industry is concerned. You can only work with the information that you're provided. Is that correct?
Certainly.
Now, in this instance, you were provided 10 things, and then there were 4 additional things that either you or the other doctors had reviewed as far as literature or things of that nature. Is that fair to say?
Correct.
And the 10 things that you were talking about were reports, an initial crime scene report, medical examiner dispatch removal report. Is that correct?
Correct.
Photographs of the incident location. Is that correct?
Correct.
And how many sets of photographs of the incident location were you provided with?
In terms of the number of photographs?
The number of photographs, or were there different sets of photographs?
Yes.
And how many sets?
I don't recall off the top of my head. I know that there was a series that were taken during the daytime as well as ones taken what appeared to be in the early morning hours.
And you were also provided video from the early morning hours. Is that correct?
From what I recall, I think it was daytime, but yes.
Photographs of the vehicle, photographs of recovered evidence. Is that correct?
Correct.
CDR report from the 2021 Lexus LX 570. Correct?
Correct.
Autopsy report, autopsy photographs. Is that correct?
Correct.
And then some other things those would be the 10 things that you were provided with. And then there were 4 other things that you reviewed or part of your team reviewed. Is that correct?
Correct.
Now, in regard to there's a section in your report called review of materials, and it talks about photographs and glass fragments and plastic fragments and things of that nature, correct?
Correct.
You also talk about a black drinking straw that was recovered on scene. Is that correct?
Correct.
However, there's no mention in the report about Mr. O'Keefe's shoe or Mr. O'Keefe's hat. Are you aware of those items as well?
Yes.
And are you aware that Mr. O'Keefe's shoe was actually found dug out from the snow, sort of flush with the curbing in front of the area where his body was found?
Yes.
Now, over the course of your work as a crash reconstructionist, and again, I don't mean this in any way, shape, or form, but I'm just curious. Typically, you're reconstructing or you're looking at someone else's reconstruction in relation to something that occurred in the past, correct?
Not always, no.
Well, my question is, sir, how many times have you actually been on like a live scene where the vehicles are still in place at final rest, where there are bodies in place at final rest? Have you ever been to the scene where those sort of conditions existed?
Certainly. We have a rapid response team that essentially we've been on site on the day of or the week of the incident. Yes.
Now, how often is that?
Not nearly as often as, like I said earlier, we primarily do litigation work. So again, by the time we're retained, obviously the scene has been is no longer present.
Scene's been cleared, items have been removed as far as evidence or other things. That's mostly what you deal with, correct?
Sure.
And as far as the hat that we were talking about before, is you aware that that was recovered as well, same day as the drinking straw on February 3rd in the area where the body of Mr. O'Keefe was discovered?
In the area of the front yard, yes.
Now, you have some familiarity through working as a crash reconstructionist with pedestrian collisions, correct?
Correct.
Is it common or uncommon for in the course of a pedestrian collision, for a shoe or glasses or a hat or something to fall off of that pedestrian in the collision sequence near where the area of impact occurs?
Well, I think that depends on the interaction between the two. If it's more of a side swipe type interaction, if we're just talking about an arm, for instance, contact the vehicle, no, I would not expect the shoe to come off. If it's something where the entire body is interacting with the vehicle, then yes, there's a greater likelihood that something like a shoe will come off. Yes.
So that is consistent in general terms with a pedestrian collision of a shoe coming off, correct?
Again, based on the interaction between the two. I wouldn't say it's a blanket statement that, again, in all pedestrian interactions, you will have a shoe come off.
And that's not the question I was asking. So what I'm asking is it generally consistent with pedestrian collisions, the shoe may come off during the collision sequence near the area of impact?
Shoes can come off in a pedestrian impact, yes.
Now, Now, again, you were testifying earlier about the damage to the Lexus being isolated in the area of the taillight, correct?
Correct.
And that was based on the information that you were providing, correct?
Correct.
Now, with respect to any of the materials that you were provided, was there anything in the materials that you were provided that indicated that just the arm or an outstretched arm of Mr. O'Keefe interacted with the vehicle?
No.
And based on your review of any of the materials that you were provided, was there any information stating that Mr. O'Keefe had been struck in the back of the head by the taillight assembly of the Lexus?
No.
And based on any of the materials, let me ask you, based on any of the materials that you provided, were you aware that Mr. O'Keefe is on video exiting from a bar minutes before crash occurs at approximately 12:11 a.m. holding a cocktail glass in his right hand?
I'm not aware of that video.
Now, other than the materials that we just went over, as far as the 10 things that you were provided, you weren't provided anything else, is that correct?
That would be correct.
And so sort of the questions that you endeavored to answer, those were questions that you didn't know from any of the materials that you were provided, is that correct?
If I understand your question correctly, there was nothing in the material that indicated the questions we were to answer, if that's what your question was.
That is my question. So there was nothing in there, is that correct?
Correct.
Can I have a moment, John?
Yes.
You talked a bit about, you have some extensive background in human factors, correct?
Correct.
And as far as visibility, and in particular, have you ever conducted a visibility analysis?
Absolutely, hundreds of times.
And you talked a little bit about conspicuity, is that correct?
Yes.
And part of conspicuity, at least one of the factors, would be a reasonable expectation of, in particular, when you're talking about a pedestrian. Part of the conspicuity factors would include sort of a reasonable expectation that a pedestrian would be in the path of the vehicle. Is that fair to say?
I don't understand your question.
When you're talking about conspicuity or visibility analysis, in particular, you're talking about something called PRT, or perception reaction time, correct?
Well, that occurs after recognition. So first, a driver has to recognize that there's a pedestrian there before they can actually respond to it. So once they've recognized the pedestrian, then you start the perception response time where, again, the driver has identified what the hazard is. They're making a decision about what to do. They might be moving their foot from the accelerator pedal to the brake pedal. So again, kind of that's the action or the time frame in which the driver is undergoing action to potentially mitigate the collision.
And perception reaction time, that's a pretty commonly used industry sort of standard as far as crash reconstruction goes, correct?
Well, I would say that it's used in the field of accident reconstruction, but as I mentioned earlier in my testimony, there isn't a blanket number in terms of perception response time. As I mentioned, it's based upon the hazard that the driver is presented with. Again, if you've got a pedestrian crossing the roadway, that's going to be one particular perception response time based upon studies and naturalistic data versus a driver suddenly stopping in front of you, right? It's not the same perception response time in every scenario.
No, understood. And there's different variables that may affect that as far as someone's age, as far as the lighting that's available, other things. Is that correct?
Sure.
And one of those things might be the reasonable expectation of a pedestrian being present in the roadway as you're driving along, correct?
Expectancy can play a role, yes.
Expectancy, what we're talking about is sort of the disparity or the difference between driving along a country road where there's no houses for miles and miles versus an urban area where there's crosswalks every 15 feet, correct?
Sure.
Now, in that expectation of privacy, how high would that be if we're talking about a pedestrian that actually exited from the vehicle that then strikes?
I don't understand your question.
Let me ask you this. If the operator of the vehicle has a passenger who then exits the vehicle and goes towards the back, would there be a high reasonable expectation that the pedestrian would be located in that area?
I don't know if I would classify it as high.
What would you classify it as?
I honestly don't know that I have a classification to it.
Now, you never looked at the defendant's vehicle in this case, correct?
Correct.
Are you aware that the defendant's vehicle is still in police custody and available for inspection?
I'm not aware of that.
Did you ever ask to look at the defendant's vehicle?
No.
Now, a typical pedestrian strike, for the most part, involves a pedestrian in front of a vehicle as it's coming down the street. Is that fair to say?
That can be one type of interaction, yes.
Is that more prominently seen as far as your field than a rear collision?
I would say that's fair.
And there are various types of sort of interactions that the pedestrian can have with the vehicle in order to cause and sort of sustain injuries. Is that fair to say?
What I would say is that there's certainly, in terms of how the pedestrian interacts with the vehicle, in terms of whether they're being wrapped onto the vehicle or projected forward, certainly there's different types of interactions, yes.
So there's like a wrap and forward projection type of collision sequence. Is that correct?
Those are two common, yes.
There's also something called a fender vault. Is that correct?
Correct.
And sort of how or where that pedestrian is positioned with relation to the vehicle is somehow, somewhat determinative of the injury sustained. Is that correct?
It can be, yes.
Obviously, you're going to see different injuries if someone fender vaults and goes over the top of the vehicle versus someone who is projected forward from the collision sequence with the front of the vehicle.
Just to clarify, again, in this matter, I was not assessing injuries. That was Dr. Rentschler. I don't have an opinion.
What I'm saying is based on your experience, so that you understand that there's a difference in the injuries that you might expect based on the type of interaction that a pedestrian has with the vehicle.
Yes.
And then if someone is wrapping forward projected and then the vehicle overruns that person, there'd be a whole other host of injuries that you'd expect to see based on being overrun by the vehicle, correct?
There could be, yes.
Now, the testing that you did with respect, these are essentially experiments that you're doing, correct?
That's fair, yes.
And am I correct in saying that in scientific experiments or in the world of scientific experiments, there are certain things called variables that you're trying to account for? Is that correct?
I would say that's fair, yes.
And essentially what you're trying to do is control as many of those variables as you can in order to best replicate whatever the conditions were at the time that what you're testing to see actually occurred. Is that correct?
Correct.
Now, what, if anything, did you do to control variables in relation to temperature?
So one of the things we did with all of the tail lamp assemblies that we tested is that we preconditioned them to approximately 28 degrees so that they'd reached a steady state temperature before we subjected them to the impact testing.
And where in your report does it say that?
I don't believe that's explicitly stated.
Is it implicitly stated anywhere in your report?
Again, I'm telling you, that's part of what we did for the testing.
I understand that's what your testimony is, but you wrote a report, correct?
Right, and I don't know that I detailed every single part of the test. Again, we summarized it.
Understood. So what did you do to control any variable as far as wind?
Well, when you're talking about a projectile such as a glass, again, that's being projected at 37 miles per hour, again, there would be probably minimal effects in terms of the wind.
Even if there was a blizzard going on?
Again, what we're going after here is ultimately conducting a test such that the drinking glass arrived at the location of the taillight. So if you're trying to say that, okay, he threw it this way and the wind blew it towards the taillight, sure, that could be a possibility.
And so I'm not trying to say anything. I'm just asking, are you aware that there was a blizzard and that there were wind gusts up to 37 miles per hour during the time that this collision occurred, and that's not accounted for in your testing?
Were you aware of that, sir?
I'm aware that there was inclement weather at the time, yes.
Now, with respect to what type of glass did you use?
So we used a rocks drinking glass. So that's a glass that has a thicker base and a shallower sidewall.
And so what I'm asking, so was it cocktail glass, was it pint glass? What kind of drinking glass are we talking?
A rocks drinking glass.
And how tall is that rocks drinking glass that you use?
If I had to estimate, I think it was about 3 or 4 inches tall, probably.
And the thickness, did you measure that as far as the thickness of the bottom of the glass?
No.
Was the thickness of the bottom of the glass thicker or more thick or less thick than the top of the glass?
Are you talking about this in comparison to the sidewall of the glass?
Talking about in comparison to itself. So you have a glass, this rocks glass. Was the bottom thicker or the top thicker?
The sidewall would be taller, if you will, than the base.
And so when you're projecting this thing out of the device that you created, whatever it was, are you facing sort of the top of the glass where you would be sipping out of, or the bottom of the glass at the tail?
So in the testing, the interaction between the taillight and the glasses was primarily between the base and the taillight.
Now, with reference to, actually a little bit about the video, and you weren't aware of Mr. O'Keefe exiting from the waterfall bar at 12:11 in the morning, about 15, 20 minutes before he struck by a vehicle. You're not aware of that?
I'm not aware of that.
Now, with reference to that particular establishment, was there anything stopping you or the other doctors that you were working with from going to that establishment, finding out what kind of glasses they had, getting an actual cocktail glass from that establishment?
I had no idea that video existed.
Did you even know that Mr. O'Keefe was at a bar before he was struck by the vehicle?
I believe that in one of the incident reports we reviewed that there was, I think, a narrative about that they had been at a bar drinking, yes.
How is it that you determined where on the taillight assembly to aim?
So we looked at the fracture pattern, and what it appeared to be that it was emanating from basically where the clear portion meets the red cover. We kind of saw that the fracture pattern emanated from that. So that's where we targeted it.
Now, when you did this testing, as far as the sort of breakage or the pieces that came off the taillight, is it fair to say that they were of sort of different shapes and sizes, broken pieces,
Sure.
consistent with the broken pieces that were found on the scene near Mr. O'Keefe's body?
Yes, I would say that's fair.
Now, I know you may not be the person for this, but just as far as your reviewed some of the autopsy report, medical findings in regard to Mr. O'Keefe, correct?
Correct.
And the injuries to Mr. O'Keefe were primarily on the right side of his body, correct?
Correct.
So there were injuries to his right arm and forearm, elbow area, correct?
Correct.
There was bruising to his right hand. Do you recall that?
Yes.
There was an abrasion to the outside or the posterior of his right leg near his knee. Do you recall that?
I don't know that I recall that off the top of my head.
And do you recall sort of the skull fracture or the laceration that immediately outside of the skull fracture was on sort of the right back of his head?
Yes.
Now, from the reports that you reviewed, were you aware that when Mr. O'Keefe's body was discovered by the defendant and two of Mr. O'Keefe's friends, that the defendant was the only one who could see him in the conditions?
Objection.
Sustained.
As far as the lighting was concerned in that area where Mr. O'Keefe's body was found, are you aware there was no overhead street ambient lighting or anything like that?
Objection.
I'll allow that.
I'm not aware of that.
And you didn't do any visibility analysis or anything in relation to this case, correct?
That wasn't a part of my scope in this case.
Well, as far as part of your scope, did you define that you indicated earlier that there were questions that you didn't find in the materials that you had to conduct experiments to prove or disprove, correct?
Well, again, the entity that retained us in this asked us to evaluate whether or not the damage to the vehicle and the injuries to Mr. O'Keefe were consistent with the interaction or in interaction between the two.
So you were at least somewhat restricted in the scope of what you could do based on the parameters given to you by the agency that hired you. Is that fair to say?
Sure.
Now, as far as any statements by the defendant to investigating troopers either that afternoon or that morning when Mr. O'Keefe's body was discovered, were you familiar with any of those?
Objection.
I'll allow that.
I'm not familiar with.
Sure.
You are unmuted.
So, doctor, with regard to the defendant's statements at any point where you did you review materials or were you made aware that the defendant said to multiple people on scene, I hit him, I hit him, I hit him, I hit him?
I'm not aware of that.
May I have a moment, Your Honor?
Yes.
Within the reports that you and the other doctors submitted, there's an indication that if either Mr. O'Keefe's arm or head had interacted with the taillight, there'd be some expectation that either blood or DNA would be contained on that taillight. Is that correct?
I believe, yes, that was stated in the report.
And at any point were you made aware that Mr. O'Keefe's DNA actually was recovered from that taillight assembly from the defendant's vehicle?
No, I was not.
As far as forensic reports, what, if anything, were you provided in reference to that? other than the initial crime scene report?
Are you talking about specific to the scene or forensic reports to the body?
Forensic report specific to the evidence that was recovered from the scene and from the defendant's vehicle.
Only what would be listed in the report.
Now, you indicated one of the materials that you were provided and you reviewed was the EDR, event data recorded data.
The crash data retrieval report, yes.
Now, have we shown anything as far as a crash reconstruction report from a trooper from the state police?
No,
And the EDR data that you observed, did that contain any sort of usable data?
there was no events recovered on the black box.
And with respect to there being no events recovered on the EDR or the black box in a pedestrian collision, is that unusual?
It is not.
And why not?
Well, because you're talking about, excuse me, a very large weight difference between the vehicle and the pedestrian. So ultimately, what the vehicle is constantly monitoring is acceleration, which gets back to a term called delta V. So when the vehicle doesn't experience a big delta V, typically the threshold for a non-deployment event where you're not firing airbags or any safety mechanisms, but the vehicle wakes up and says, hey, there was something that I potentially hit. It's usually at a threshold of about 5 miles per hour. So again, given the weight difference, we usually don't see delta Vs that high with pedestrians.
And is that in some respects because what the EDR and what the safety restraint systems are designed to protect is the occupants of the vehicle, correct?
That's fair, yes.
I mean, there are more innovations as far as vehicles that are more modern or released earlier that have certain pedestrian or protections for other vehicles, but primarily what they're focused on is the occupants of the vehicle, correct?
Correct.
Now, at any point in time, have you shown any tech stream data, Toyota tech stream data from the defendant's vehicle?
No.
So you weren't shown any data indicating that the defendant's vehicle was being operated in reverse.
The objection sustained. Next question.
So with regard to the defendant's statements, were you also not told that the defendant told several people that she had just gotten into a fight with Mr. O'Keefe right before she dropped him off at 34 Fairview Road?
So that's sustained.
Now, with regard to pedestrian collisions, you're familiar with sort of the physics term, I'm presuming, doctor, as far as like center of mass?
Yes.
And what kind of role does the center of mass for a pedestrian play in relation to the center of mass of a vehicle as far as how the two interact?
Well, it depends, again, on the vehicle structure. And again, when you're talking about where's the hood height, the bumper height, and the CG or the center of gravity of the pedestrian, that, again, will kind of dictate how they interact with between the vehicle and the pedestrian.
Now, typically, a typical pedestrian collision, again, that we were speaking about before, is in relation to a pedestrian struck by the front of the vehicle, correct?
Correct.
And so in a typical pedestrian collision, that involves more of an assumption of the velocity of the striking vehicle than you would see occur in sort of a side swipe. Is that correct?
I'm sorry, can you repeat the question?
In a typical pedestrian collision, that would involve more of an assumption of the velocity of the striking vehicle by the pedestrian than you would see in a typical side swipe collision. Is that correct?
If I understand your question correctly, yes. If the vehicle is striking the center of gravity of a pedestrian as opposed to just, for instance, a limb, yes, the center of gravity or the body will be accelerated up to that speed.
Now, with respect to the defendant's vehicle, again, you never actually looked at the defendant's vehicle. Is that correct?
It wasn't necessary.
And did you look at the actual taillight housing from the defendant's vehicle?
I had sufficient photographs of the taillight.
Did you ever look at the actual physical broken pieces of the taillight from the defendant's vehicle?
Again, I had sufficient photographs that documented the fragments and pieced them together.
And you're aware, at least, that the fragments that were recovered on scene were then sort of put back together and overlaid over the taillight housing that was taken from the defendant's vehicle?
Yes.
And through any of the pictures of the photos that you observed, did you ever see a piece of metal protruding underneath the broken and shattered plastic pieces from the taillight?
I believe it was a plastic chrome piece.
And when you were doing the testing as far as shooting the drinking glass at the taillight assembly, that taillight assembly was sort of held there by vice grips or something like that. Is that correct? It wasn't actually physically attached to a vehicle that you were shooting at?
That's correct.
Now, as far as that, you're familiar with, there was a piece of a broken drinking glass that was recovered from the same area of where Mr. O'Keefe was found. Is that correct?
Amongst the fragments of the taillight, yes.
And are you familiar with Mr. O'Keefe's DNA being present on those pieces of the exterior of a broken drinking glass located near his body?
I don't believe so.
Now, as far as Mr. O'Keefe's clothing, his fingernails, are you aware that there was DNA of Mr. O'Keefe and no one else recovered from both his fingernails and from a variety of areas of his clothing?
Objection.
Sustained.
Now, from the crime scene reports that you reviewed, are you aware that there was human hair that was located on the right rear quarter panel near the dent that you were talking about?
Objection.
I'll allow that.
Yes.
Are you familiar or are you aware that subsequent mitochondrial DNA testing found that the mitochondrial DNA profile for that hair was consistent to a probability of 99.895% with the mitochondrial DNA profile of Mr. O'Keefe?
I'm not aware of that.
Now, were you also aware that the broken drinking glass with Mr. O'Keefe's DNA on it was found to be consistent with the broken drinking glass pieces that were found in the street?
Objection.
I'll allow that.
Can you repeat the question?
Sure. Were you aware that the pieces from the exterior of the broken drinking glass found near Mr. O'Keefe's body with his DNA on it were then found to be consistent with pieces of broken drinking glass that were located in the street of 34 Fairview Road?
Yes.
Were you also aware that pieces of glass that you were talking about from the defendant's bumper were found to be consistent with pieces of glass recovered from the street in front of 34 Fairview Road?
Yes.
Were you aware that there were microscopic pieces of red and clear plastic, about a 1/16 of an inch by a 1/16 of an inch, that were recovered from Mr. O'Keefe's clothing that were then found to be consistent with the tail?
No, I don't believe so.
Now, as far as, again, you weren't provided with any sort of a reconstruction report from a Trooper Paul from the state police?
No, I was not.
You're not aware that he took measurements from the ground to where certain items were on the vehicle?
Objection.
The objection sustained. He didn't see the report.
Your Honor, can we approach?
Sure.
You are unmuted.
Yes.
My apologies, Brian. Just a moment.
Yes.
Now, doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out of a garage and making contacts with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th?
No.
Now, as far as from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case?
At that speed, no.
Then we can do our 2 o'clock.
So there were about 10 items that you were provided that you reviewed, is that correct?
Correct.
And a number of different items that I just asked you about that you weren't provided with or you weren't aware of, correct?
Correct.
And again, in your report, in the very first paragraph, you indicate, however, ARCA reserves the right to supplement or revise this report if additional information becomes available, correct?
Correct.
I have nothing further.
All right, Mr. Jackson.
Thank you, Your Honor. Very briefly, Dr. Wolf, you were asked on cross-examination a couple of questions about hair, DNA on the outside of the taillight lens, I'm sorry, the taillight housing, and glass material. You recall that?
Yes.
Does any of that change your opinion about your opinions and conclusions in this case?
Objection.
I'll allow that.
Absolutely not.
What is your conclusion as to whether or not the damage to the vehicle and the injuries to the human being are consistent or inconsistent with the vehicle interaction?
Objection.
Sustained. All right, Dr. Wolf, you are all set, sir.
Thank you.
Yeah. No, I'll do it back there. Thank you.
Yeah.
Yes.
Your Honor, we would ask Dr. Andrew Renshaw to join us, please.
Okay. While he's coming in, just very quickly about scheduling.
You are muted. You are unmuted.
Can we go a little past one to keep going with this, if that's okay? Everybody's nodding. All right, thank you.
Step right up and drop the step on me. Remain standing, face the floor.
You solemnly swear the evidence you record during the case, and the truth, the whole truth, and nothing but the truth, so help you God.
I do.
May I inquire?
Yes.
Doctor, could you please state your first and last name, spelling your last name for the record, please?
Certainly. Andrew Rentschler, Rentschler.
And what do you do for a living, sir?
I'm a biomechanical engineer and accident reconstructionist.
And who do you work for?
I work for a company called ARCA LLC.
How long have you been in that position as working for ARCA, first of all?
I've been with ARCA for about 16 and a half years now.
And you indicated that you're the director of biomechanics and human factors, is that right?
I am. I'm a vice president and the director of biomechanics for the Midwest Division.
Can you tell us what education, training, and background qualifies you to perform your duties as the director for biomechanics and human factors?
Sure. Well, I've got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanical engineering from the University of Pittsburgh in 2002. And then I went to get my doctorate or my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Doctor, do you specialize in research and analysis to evaluate specifically the study of the relationships between crash injuries and crash forces?
I do, yes, sir.
And when I say crash injuries, we're talking about to human beings.
That's right. Injuries to human beings, whether it be in a crash, motor vehicle accident, slip and fall, industrial, any type of setting where there's an injury to the human body, I evaluate basically that event and the mechanisms responsible for producing those types of injuries.
Doctor, does it also include the study of and understanding of human kinematics?
It does, yes.
As well as human tolerances?
Yes, sir.
We all know what tolerances mean. What does kinematics mean?
So kinematics is really just the motion of the human body, and it's the study of the human body, how the body moves under different circumstances, whether you're in a car that's struck from behind, what direction will your body move, slip and fall, how will your body rotate and move. It's really looking at the motion and the response of the body.
Are you certified by any professional associations?
I have a PhD. There's no professional licensure for biomechanical engineering. PhD is the highest basically certification you can get. And I'm also a member of SAE, Society of Automotive Engineers, as well as the American Society for Mechanical Engineers.
Have you received additional training and education in further beyond your PhD and the associations that we just talked about?
I have, yes, sir.
Can you describe, without going through all the detail, describe the kind of continuing education that you engage in?
Well, I attend seminars and professional classes with respect to biomechanics as well as accident reconstruction, but looking at new technology and research with respect to injuries. For instance, motor vehicle accidents, if there's new safety measures such as airbags, seatbelt pretensioners, auto detection devices on vehicles. So really kind of staying up to date with the current research and literature that's out there.
So your specialty, your subfield, if you will, in terms of your engineering degree, and education is literally in accident reconstruction and the effect that accidents and incidents can have on the human body. Is that right?
It is, yes. And biomechanics is really, it is looking at injury to the human body. So, we use traditional engineering principles and apply it to the body because an injury is just an engineering problem. Instead of looking at a piece of steel that if you know the dimensions and size and you apply a force, it'll bend and break, we look at the human body. How much force does it take and how does the force have to be applied to get a humerus fracture or an intervertebral disc injury or any type of injury? There's specific forces and mechanisms you need to produce those injuries. And that's what I do as a biomechanical engineer.
Is there a difference between a biomechanical engineer and a doctor
There is, yes.
in terms of injuries?
Yes.
Tell us about that.
So we really approach injuries from two different directions. Someone has an injury, you go to the doctor, you go to the hospital, the medical doctor will diagnose that injury, determine the best way to treat it, and determine what the prognosis is. As a biomechanical engineer, I look at that injury from a different direction. Here's the injury. Well, how did that injury occur? What type of loading did you need to actually produce that injury? How much force was required? What happened to your body to actually cause that injury to occur? So we approach it really kind of from two different areas. And certainly the doctors diagnose the injuries and determine what they are. And then the biomechanical engineer will come in and we'll look at that injury. And not only how's it produced, but ultimately our hope is to mitigate and prevent injuries from occurring, whether in motor vehicle accidents, sports settings, industrial settings, anywhere there's interaction with the body and the environment, we want to try and make it safer for individuals.
So you're not diagnosing an injury as much as you are trying to figure out the mechanics and the forces behind the injury. Is that right?
That's right. I'm not a medical doctor. I wouldn't diagnose an injury, but given an injury, I understand the mechanics of how that injury is produced and what you need to actually cause that injury to happen.
Are you also published in the field of biomechanics and or engineering?
I am, yes, sir.
Can you describe that? Okay.
When I did my graduate work at the University of Pittsburgh, I worked at a place called the Human Engineering Research Lab. And it was associated with the VA in Pittsburgh as well as the University of Pittsburgh. And so we looked at people with disabilities. Well, one of the big things that we did, one of the major points was people in wheelchairs. So if you have to propel a manual wheelchair, you put a lot of stress and force on the arm, the shoulder, the elbow, the hands, carpal tunnel. So we look at the injuries that are produced during those types of events. How can we reduce the force acting on the body for someone like that? So it's looking at, again, how the body responds, how we can set up a chair differently to actually reduce the amount of force someone might experience doing that type of an activity.
Have you qualified as an expert in the past in the area of biomechanical engineering and human factors?
I have, yes.
In furtherance of, let me ask it this way, were you asked to engage in an analysis, ARCA, to be engaged in an analysis of the incident that is currently before the court?
I was, yes, sir.
Did you produce, or did your team produce a report about your opinions and conclusions, including the testing and the methodology that went behind those opinions and conclusions?
We did, yes.
You were not hired by the defense in this case, correct?
No, we were not.
You were not hired by the Commonwealth in this case.
That's correct. We were not.
When you started your analysis, you didn't know who we were. You did not know who the Commonwealth was.
That's correct.
You never heard of Jeremy case.
I had not, no, sir.
Were you contacted by my office after you provided your report, correct?
That is correct, yes.
Were you ever contacted by the Commonwealth?
Not that I'm aware of, no, sir.
And you and I never discussed the substance of your testimony, correct?
That's correct. We have not.
Would you consider that your analyses, your conclusions and opinions in this case are completely independent of any party in this room?
Objection.
Sustained.
You've not been paid by the defense, is that right?
I have not, no, sir.
And you do not answer to us in any way.
I do not. That's correct.
You indicated that you and your team were asked to undertake a review of the circumstances. What exactly did you review in coming to your opinions and conclusions and performing the tests that you performed?
Well, we looked at, there was police reports with respect to the incident, medical records for Mr. O'Keefe, as well as the autopsy report, photographs of the evidence in this case involving the Lexus, the tail lights, the incident scene where the evidence was found, as well as some other documentation.
And you also worked with Dr. Wolf, who just left the courtroom, correct?
I did, yes.
Did you two have sort of a distinct role in, although working as a team, a distinct role in making determinations and conclusions about the incident?
That we did. There was a distinction. Certainly some of our work overlap, but there was a distinction with what each of us actually did and performed with respect to this case.
Following your review and your investigation and analysis, did you make any determination as to whether any of the injuries suffered by Mr. O'Keefe in this case were consistent with producing the damage that was seen on the SUV?
I did, yes, sir.
And what did you base your opinion on?
My opinion was based on certainly the medical records, the description of what the injuries were, the damage that we have to the Lexus, primarily the right rear tail light cover, as well as we perform testing to evaluate the strength of that tail light cover and look at the damage associated with different types of impacts. And also to look at the overall evidence of where everything was found, where Mr. O'Keefe was found, what the injuries were, how they may or may not have occurred based on the damage we have to the vehicle.
So did you look specifically to find whether or not you could determine the forces required for Mr. O'Keefe to suffer the injuries that you saw in the records, medical records, et cetera?
I did, yes. I determined in my analysis whether there was sufficient force with that damaged taillight and interaction with that taillight to produce any of the injuries that were listed or diagnosed in the autopsy report in the medical records.
What, generally speaking, what injuries would you expect to see in a vehicle-pedestrian interaction at, say, 24 miles per hour?
Objection.
I'll allow that, just generally, Dr. if you would, please.
Yes, Your Honor. So 24 miles an hour, once you get up to that speed, you start to see fractures. You see significant ligament and tendon damage. I mean, usually about 15 mile an hour impact is where you start to see damage to, for instance, the leg and the knee. At that speed, you're going to produce, if you impact the vehicle, you're going to produce upwards of 1,000 pounds of force on the body, depending on what part of your body impacts the vehicle. So certainly at 25 miles an hour, you start to see significant injuries occur.
Is that true for any part of the body that is struck, whether it's center mass or an extremity? 1,000 pounds of force because of the speed of the vehicle?
Well, force is equal, Newton's second law of force is equal to mass times acceleration. So the acceleration is going to be the same. It depends on the mass of whatever body part's being hit. So from the testing that we did at 15 miles an hour, we used a head form, which weighs about 11 pounds. And that produced almost 1,000 pounds of force, a little under that for the head. So anything that weighs 11 pounds is going to produce almost 1,000 pounds of force. The heavier the object, if you get hit center mass, that's going to be even greater force because that's more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body.
Did you review, in furtherance of your conclusions and opinions, did you review records that indicated injuries to both a head as well as an arm, the right extremity, right arm?
I did, yes, sir.
Taking those one at a time, is the injury to the head that you saw consistent with having been struck by a vehicle at 24 miles per hour?
It is not, no, sir.
Can you explain why that is?
There's a couple of reasons. First of all, and the main reason is that to get the injury, it was a fracture at the occipital region of the head, which is basically on the back bottom part of the head. So in order to have that part of the head contacted by the taillight, you would somehow have to have a configuration or be standing in a manner that the rest of your body doesn't get hit because there's no other significant injuries to the body. If there's enough force to cause a skull fracture, then there's going to be certainly enough force to cause injury to the rest of the body. So first of all, you have to determine how could you configure somebody could actually be standing to have only the head impacted, the back of the head. And even if that was the case, if somebody positioned themselves in such a manner to have that occur, you're still going to see other injuries related to that. For instance, with the cervical spine, over 1,000 pounds of force acting on the head, you're going to get significant cervical injuries, fractures, disc injuries, tendon and ligament injuries. So the fact that we only have that head injury and only damage to the occipital portion of the skull is inconsistent in this case with being struck by that tail light. And then there's also the evidence that we saw when we did the testing. At 15 miles an hour, where we dropped the head form, so that would be akin or like a vehicle backing up at 15 miles an hour hitting the head, we had more damage to the tail light in that test than what we saw with the subject tail light cover. So if you're going 24 or 25 miles an hour, even faster, you're going to see even greater damage, greater fracturing of that rear tail light. And we just don't have that in this case. So both the physical evidence as well as looking at the biomechanical aspects of it are inconsistent with that head injury occurring due to impact with the rear of the Lexus. Shifting
to the arm, are the same forces at play if instead of the head making contact with the tail light, it's an outstretched arm, for instance, at the elbow area of a human being, the person 73 inches tall, weighing 215 pounds.
Objection.
The objection sustained. Ask it differently.
Sure. Shifting to the arm, are the same forces at play if instead of making contact with a head, you make contact with an arm, an outstretched arm?
They are. I just explained the force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get that same force, almost 1,000 pounds.
Does the arm weigh the same as the head?
It does, actually, almost identical, because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. So your arm, basically your whole arm, is about the same, weighs the same as your head.
So is your analysis the same then if the arm, close to an 11-pound arm, made contact with the taillight traveling 24 miles an hour, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Objection.
I'll allow it. Watch the leading room.
Sure.
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that taillight, you're going to get even more significant fracturing, more damage to that taillight at a higher speed than what we saw.
So was the taillight damage consistent or inconsistent with striking an arm?
It was, our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm. Yes, sir.
Okay. I want to shift back to the head injury that you saw. Was the head injury that you saw consistent with falling backward from a standing position onto a rigid surface?
That's certainly one of the possible scenarios that would create the injury mechanism. You fall backwards, strike your head on concrete. That can produce thousands of pounds of force on the head. And so that's certainly a scenario where you could produce that damage. If someone was standing, they fell backwards and struck their head on the roadway or on the curb or a hard surface.
So I was going to ask, if you think you may just answer my question, those kinds of force multipliers require a hard or rigid surface or not?
They do, yes, sir.
So grass and dirt would not produce the same sort of force?
Grass and dirt, no, that would certainly not produce the same amount of force as hitting your head on concrete.
And if it was grass and dirt with a little bit of snow on the top of it, what effect is that?
That's going to dampen and lessen the force even more so.
What injuries, I want to shift back to the arm. I know I'm going back and forth, bear with me. Talking about the arm, if presuming a strike at, say, 24 miles an hour on just the arm, what kind of damage would you expect to see on the arm, irrespective of the vehicle?
You can see significant damage on the arm, especially if it hits at that taillight. Enough force to actually cause fracture of that taillight, that force is going to be concentrated at an initial point. And you're going to see at that point, you're going to see probably the most damage to the arm and to the skin there. So remember, at 15 miles an hour, that's about almost 1,000 pounds. So 24, 25, it's even greater. So that amount of force on the arm, certainly you're going to see extensive subcutaneous lacerations, bruising, contusions. You're going to see most likely fracture of the arm as well. You're going to see significant damage. Just imagine having your arm out and being struck by a car at 25 miles an hour. There's going to be significant damage, more so compared to simply the abrasions that were diagnosed and documented on the arm in this case.
You did look at multiple photographs of the arm in this case, of John O'Keefe's arm in this case, correct?
I did, yes, sir.
All right. Were the injuries that you saw on John O'Keefe's right arm consistent with having been struck by a vehicle in the manner that you just described?
Objection.
That's sustained, Mr. Jackson.
You reviewed injuries specific to John O'Keefe, correct?
I did, yes.
Taking that as a hypothetical, would the injuries that you saw, generally speaking, hypothetically be consistent or inconsistent with having been struck by a car at 24 miles an hour?
Objection.
Sustained.
May we approach?
Yes.
You are unmuted.
Can I inquire, Your Honor?
Yes.
Thank you. If you were to presume, for purposes of my question, that an arm was struck by a vehicle, taillight traveling at 24 miles an hour or thereabouts, would you expect to see patterned abrasions with no bruising?
Objection.
Or just, what would you expect to see?
What would you expect to see?
So again, I would expect to see significant trauma to the skin, to the bone, to the tendons. I wouldn't expect to see just abrasions, pattern abrasions. I mean, abrasion by very definition means that it's trauma to the skin, which is created through rubbing or grinding or friction. So it's basically something rubbing against the skin that basically wears away that top layer of skin. It's not blunt force trauma. If you have blunt force trauma, that produces a contusion or a bruising. It's not a laceration type injury where you have a cutting injury that actually produces a cut or a significant laceration. It's really just rubbing along the skin. So that would be inconsistent. If you have an arm that's actually struck at 25 miles an hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm and it's moving forward into the arm. So if that actually caused fracturing of the taillight, then parts of that taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. I didn't see any of that, basically just superficial abrasions, which all appear to have a similar amount of force. There's not a difference. That's the other thing. If you had a taillight shatter and explode on an arm, you would have some areas where you would have very deep contusions or lacerations, others lighter areas. But when you look at the abrasions that were noted in this case, they all appear to be the same force, generally the same direction and the same severity, which would be inconsistent, in my opinion, with being struck at 25 miles an hour.
Generally speaking, do you look for consistency in size of an object striking a body and the injury that the body suffers from being struck by the object?
Absolutely. Yeah. I mean, size is a big part of it, certainly. Yes.
Did you do any measurements of the size of the taillight, the width of the taillight that was shattered?
Yes.
And what was that width, if you can recall?
I think the width we looked at was maybe 6 inches or so.
In review of your, in coming to your opinions and conclusions, did you look at the arm of John O'Keefe just sort of laid out, straight out?
I did. Yes, sir.
Did you see where the injury started and stopped, or began and ended, however you want to put it, in terms of size?
Yes, I mean it started from the upper arm and then extended down into the forearm, which was greater than 12 inches of length, where you see those injuries and those abrasions occur.
Did you come to any conclusions or opinions concerning the size differential between the taillight and the injuries that you see?
Objection.
Sustained.
Generally speaking, would you expect if there was an injuring event that the size of the injury would be consistent with the thing that produced the injury?
Yes, generally speaking, you would certainly expect that. And again, you would normally and usually be able to see an initial point of contact, because that's where the most force is going to occur, where it causes that taillight to break. So you would have an area of severe damage, and then it would extend out likely to the edges of where it would contact the rest of the taillight.
From a biomechanics and or a physics standpoint, or engineering standpoint, is it reasonable if someone is standing with their arm extended to be hit by a moving vehicle, let's say 25 miles an hour, and the center mass of the body to be projected?
Objection.
Ask it differently.
Is it consistent in your view with engineering principles and physics principles that you know, if an arm is hit, extended, not the body, just the arm is struck, for the body then to be projected?
Objection.
I'll allow that.
It's not, no. So if we have contact, your arm's out, we have contact to the arm. I mean, first of all, it's a ball and socket joint. So the arm can move independently of the rest of the body. So with enough force, even if you're contracting your arm and trying to hold it out as tight as possible, it's going to overcome that muscular contraction and basically just move the arm. But secondly, it all depends on your center of mass. The center of mass is kind of the equilibrium point of your body of where your weight's distributed. And for most normal people, the center of mass occurs at your umbilicus or your belly button. So wherever your belly button goes, that's where your body's going to move. They teach this to football players, right? If you're a defensive back and a running back comes around the corner and it's you against him, they tell them or they teach them to watch the waist and watch the belly button. It doesn't matter what your head or your arms do or what their feet do. Wherever their belly button goes, that's where they're going to go. So that's what you want to tackle. So even if you had your arm straight out, again, we said it would move because of the joint. But let's assume you had a metal pole sticking out of your arm, out of your body instead of your arm, and that metal pole gets hit. What's going to happen to your body? It's just going to spin around, right? Because it's producing a moment arm, which produces a torque on the body. So your body's going to basically spin. In order to get that body, or the complete body, over, for instance, 10, 20, 30 feet into the yard, you need a force acting at the center of mass. You need an external force pushing the body that way. And that's not going to happen if you just hit the arm. It's not enough force. It's not the right mechanism to actually cause the body to somehow move that far over.
Assuming that a body was struck with enough force at center mass to project that body 20, 30 feet, what injuries would you expect to be produced on that body?
Objection.
Sustained.
If you did have a body that was projected a distance, what injuries from a car, what injuries would you expect to see on the body?
Objection.
I'm going to see you at sidebar the last time on this.
May I interrupt?
Yes.
Doctor, do you have my question in mind? You need me to repeat it?
Maybe repeat it, yeah.
Easy for you to say. Assuming that a body was struck center mass with enough force from a vehicle traveling at whatever speed to project the body off the ground, would you expect to find injuries on that body?
You would, and you would actually see that there's specific injuries because let's say you're standing forward and you get hit on the right side with a vehicle. You're going to get injuries and damage to the right side of the vehicle as that vehicle impacts you. It depends on the profile of the vehicle, how high the hood comes up, whether you're going to wrap up onto the hood, or if it's a van or the back of an SUV, it will project or push your entire body to the left. So you're going to get initial contact and injuries to the right side of your body. And then if it propels you into the air, you're going to get airborne and then you're going to contact the ground, usually with the left side of your body. So then we're going to see a correlation of injuries to the left side of your body as it slams down onto the ground as well. And at those speeds, normally you would also see more abrasions, greater abrasions or road rash along the entire part of the body as your body then would slide until it came to the point of rest.
And you did not see that in this case.
Objection.
Thank you.
May I have a moment, Your Honor?
Yes.
Thank you, Your Honor. I have nothing further to say.
Mr. Lally?
Good afternoon, sir.
Good afternoon.
Now, you, in conjunction with the other doctors on your team that conducted the analysis and testing in this case, you wrote a report, is that right?
We did, yes, sir.
And that report, excuse me, was issued on February 12th, 2024, is that correct?
I believe that's correct, yes.
And within the first paragraph of that report, the last two sentences state, this analysis is based on information currently available to ARCA and is only to be only to be issued in its entirety. However, ARCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
I believe that's correct, yes, sir.
Now, the information that you received and that you reviewed either individually or as a team, that included some state police reports, is that correct?
Yes, sir.
Some Canton Police Department reports, correct?
Yes,
Some scene photos, is that correct?
that's correct, yes.
Medical examiner dispatch removal report, is that right?
I believe so, yes, sir.
Some videos from the location of 34 Fairview Road, is that right?
Yes, sir.
Some photographs of the defendant's vehicle, the 2021 Lexus LX 570, is that correct?
Yes, sir.
Photographs of evidence that was recovered from the scene, is that correct?
That's correct, yes.
CDR reports from the defendant's Lexus.
Yes, sir.
And then essentially there were some other materials, whether they be literature or other things that you and your team of other doctors reviewed over the course of formulating your opinions in this case, correct?
That's correct, yes, sir.
Now, in regard to evidentiary materials that indicates within the report that were reviewed, you talk about the lens cap to the taillight assembly photographs of that nature, and then there's mention of a black straw that was found on scene, correct?
Yes, sir.
There's no mention in the report of either Mr. O'Keefe's shoe or his hat, correct?
Objection. May we approach?
Yes.
You are muted.
Do you need a couple minutes, Mr. Lally, or do you need a minute?
No? Fine, no. Thank you. Doctor, are you familiar with a term called compression abrasions?
Compression abrasions? Yes.
And am I correct when I say compression abrasions are essentially when direct pressure from a blunt object together with slight rubbing movements produce skin and epidermal crushing? Is that what your understanding of the term is?
Yes, sir.
And you're familiar with patterned abrasions?
I am, yes.
And pattern abrasions are injuries that show a distinct pattern that may reflect the shape of the impacting blunt objects that you may see with reference to injuries that are left by that blunt object. Is that correct?
That's correct. Yes, sir.
Now, as far as in general terms, from what you reviewed, at any point in time, did you look at a state police reconstruction report?
I don't believe that I did. No, sir.
You weren't provided with that, is that correct?
That's correct. I don't believe so.
You weren't provided with any sort of forensic reports, DNA or anything like that, is that correct?
I don't believe so. No, sir.
And you never actually looked at the physical car, is that correct?
I did not. That's correct.
And you're aware that the physical car, being the defendant's car, is still in law enforcement custody and available for inspection if you had wanted to? Are you aware of that?
I think I'm aware of that. Yes, sir.
But you never made that request, is that correct?
That was not necessary in this case to inspect the vehicle.
If it was necessary or not, you didn't make that request, correct?
Yeah, I don't remember if we made that request or not. We obviously didn't look at the vehicle, but it wasn't necessary in this case.
Did you ever look at the actual taillight pieces or the taillight housing, is that correct?
Not the actual. We looked at photographs of the evidence. Yes.
Now, the injuries that you observed or reviewed in materials in regard to Mr. O'Keefe were primarily on the right side of his body, is that correct?
Well, sir, on the right arm and the posterior aspect of the right arm, yes. And then the skull fracture was a little bit to the right, the occipital fracture.
Also bruising on his right hand, is that correct?
There was bruising on the back of his right hand,
On the
yes.
dorsal aspect?
Yes, correct.
And there was also bruising on sort of the posterior of his right knee, is that correct?
There was a small bruise, I believe, yes, sir.
Now, with respect to within your report, you talk about the numerous linear abrasions on the posterior of Mr. O'Keefe's right arm and forearm, correct?
Yes, sir.
And in relation to those injuries, there's a sentence in which you or whoever authored this part of the report, assuming it's you, indicate that furthermore, any such injuries would be highly improbable if Mr. O'Keefe was wearing a jacket, correct?
Yes, sir.
Are you aware that Mr. O'Keefe was not wearing a jacket other than a long sleeve sort of hooded shirt?
I believe that came to light afterwards. Again, it doesn't affect my actual opinions in this case, but it was a sentence added in there. Yes, sir.
And so also within your report, same paragraph, you indicate blood and DNA transfer would also be highly probable under such circumstances, none of which were reportedly found on the tail lamp assembly or any of the fractured pieces, correct?
Correct.
Are you aware that DNA consistent with that of Mr. O'Keefe was actually found on the tail light housing from the defendant's vehicle?
I am aware after we wrote or issued the report that it became known to us that I believe DNA was tested and some DNA was found, I believe a small amount. I don't believe any blood evidence was located or found on any pieces, but there was indication of DNA on the taillight housing.
There was also DNA matching Mr. O'Keefe that was found on the exterior of a piece of drinking glass that was found right near his body.
I believe so, yes, sir.
And there was also pieces approximately 1/16 of an inch by 1/16 of an inch of clear and red plastic that was subsequently found to be consistent with the defendant's taillight that was found embedded within Mr. O'Keefe's shirt.
Within the shirt, I believe, yes, sir. Not his actual body.
And so this is all things that you found out after you issued your report in February of 2024, correct?
That's correct, yes, sir.
Now, when you were talking about the injuries to the back of the head of Mr. O'Keefe, consistent with coming in contact with a hard surface, correct?
Yes, sir.
Would that hard surface include if the ground was frozen?
Well, you'd have to perform an analysis actually, because you'd have to determine how hard that ground was. You'd have to look at the freeze and thaw cycle, probably leading up to weeks of that. You can't just look at ground and say, well, it's below freezing, so that ground must be frozen. I mean, is it a possibility? It may be, but you have to go through an actual analysis and procedure to determine how hard that ground is and whether it could have produced those injuries.
So it is something that's capable of being done by you, is that correct?
Performing that type of an analysis? You could go through and do it, sure, yeah.
And you didn't do it, correct?
No, I did not do it. No, because there's no need in this case. We don't know what happened in this case. There's no indication of, certainly it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there. And the damage with the car is inconsistent with him being struck by it. So whether the ground could cause it or not, the roadway could cause it, the curb could cause it, a back could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't have enough evidence based on what you were provided, isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't deny the science and the physics as to what would have happened if he was struck by the vehicle. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do.
When was it that you looked at this additional material? Who provided it to you?
We were informed after a report was issued that DNA was found. And that was really the primary issue. I believe that some DNA was found on the housing, which, again, there's numerous explanations or ways that DNA can get on a light housing.
Let me ask you this, sir. With regard to the materials that you were provided with, was there anything in there that stated that Mr. O'Keefe's skull fracture on the back of his head was caused by contact with the taillight?
No, I don't believe there was anything in those materials that stated
Is there
that.
anything in those materials that indicated or that anyone stated at any point in time that Mr. O'Keefe's arm was outstretched at the time that he was struck by the vehicle?
No, sir, there wasn't.
Was there anything in there indicating that his arm was tucked in at the time that he was struck by the vehicle?
There's no indication in any of that evidence of what he may or may not have been doing, how he may or may not have been positioned. I mean, that's the whole issue. There's no evidence to indicate what may have allegedly occurred in this case.
Now, a typical pedestrian collision that you see through the course of your work involves a pedestrian being struck by the front of a vehicle. Is that fair to say?
I see all types of different people getting run over backwards, cars spinning, hitting sideways, frontal impacts certainly occur, yes, but we see pedestrians getting struck by all parts of the vehicle.
I'm sure you see all kinds. What I'm asking you is predominantly when you see a pedestrian collision, the typical pedestrian collision would be a pedestrian crossing a road in front of a vehicle as it's approaching. Is that correct?
That's certainly not uncommon, yes, sir.
Now, as far as maybe describe a little bit on your direct testimony, as far as there's differences in the type of injuries that you would expect or anticipate depending on how the vehicle interacted with the pedestrian in a pedestrian collision, correct?
Yes, sir.
And as far as you're familiar with what's called the sideswipe collision?
Yes, sir, I am.
And am I correct when I say that in a typical pedestrian collision with pedestrian crossing in front of a vehicle, there are a number of different types of interactions as far as a wrap and a forward projection versus a fender ball versus a number of different ways that a pedestrian can interact with the front of a vehicle, correct?
It depends on the position of the pedestrian and certainly the profile of that vehicle and the speed of the vehicle. Yes, sir. There's many different factors involved in it.
And so in a typical pedestrian collision, when a pedestrian is struck by the front of the vehicle, that involves more of an assumption of the velocity of the striking motor vehicle by the pedestrian than you would expect to see in a sideswipe collision, correct?
Well, I mean, yes, generally speaking, a sideswipe means that the person or the pedestrian in the vehicle don't obtain a similar or common velocity. So if you're standing in front of a car and it hits you, it's going to speed you up to that same speed and then disengage. The sideswipe means that there's not this mass-to-mass impact. By its very nature, sideswipe has minimal forces. We see it even between vehicles that just rub against each other. So if there's a sideswipe impact with a pedestrian in a vehicle, there's going to be very little damage to the pedestrian. And similarly, there's going to be very little movement. There's really no force at all acting. For instance, if a car came and swiped by your arm, but didn't have enough force or enough contact to cause any damage, well, it wouldn't actually cause any movement of the person either. So a sideswipe by its very nature involves minimal impact, minimal forces, minimal velocities.
You also contain in the reports that you at least co-authored, there's an indication that Mr. O'Keefe's injuries, at least to his skull, the fractures to his skull, are consistent with him having been pushed or possibly been impacted by the subject Lexus and fallen backwards, striking his head. Isn't that correct?
Yeah, so that's another possibility.
Sorry, sir, yes or no?
No, let him answer. Let him answer the question.
So if we're saying that there's enough force if you fall backwards to strike your head and cause that skull fracture, well, he could have slipped and struck his head. The car could have backed up and not known that he was there and nudged him and caused him to fall. I mean, any event that would cause him to fall backwards obviously would result in him striking his head. So there's numerous, almost infinite possibility of different scenarios that could result in that type of an event.
Okay.
Mr. Jackson? Okay, Dr. Wenchel, you are all set, sir.
Thank you, Your Honor.
Okay, jurors, I want to see counsel for the last time at sidebar right now.
Yes.
Okay, jurors.
You are unmuted.
Thank you, Your Honor. With that, witness rests.
Okay, jurors, that is the evidence in this case. After all these weeks, that's the evidence that you will hear in this case. The lawyers and I still have work to do for tomorrow. But tomorrow morning, we will have closing arguments of counsel. They'll get an hour apiece to be able to argue this case to you. I'll instruct you on the law, and then 12 of you will begin your deliberations sometime tomorrow. Okay, so with that, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Let us know. We'll see you tomorrow.
All rise for the court, please. Senator Crowley, please.
Jimmy, I'll have to turn it on that one. I'm sorry? I'll have to turn it on a second. Good afternoon, Ms. Yes.
Good afternoon, Your Honor. Tracy Cusick, also for the Commonwealth.
Good afternoon, Ms. Cusick.
Good afternoon, Your Honor.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. Good afternoon, everyone. Kelly Portis on behalf of Mr. Walsh.
Good afternoon, Mr. Porges. I'm glad you're joining us. Good afternoon, Mr. Tipton. It's nice to see you all. What is our next event? And do you want to get a tentative trial date? Are we far from that?
Well, if I could bring up the speed of discovery, that might put
Okay.
things in context.
Sure.
I filed a notice of discovery in court. What I had previously turned over all of this, I believe, at the end of March to counsel.
Okay.
I can tell the court that I've received all of the crime lab materials and I've just finished downloading them today. So there's another notice of discovery going to counsel for all of the crime lab materials, with the exception of the state DNA lab expects to finish their testing on items at the end of this month. So there'll be more discovery coming from that.
How many items do they have?
I believe there's about 12, Your Honor.
Okay.
And then Bodie has items that are exhaustive. And so I was speaking to Mr. Tipton in the hallway about decisions that might need to be made about having an expert go and do that or a waiver. So there is still work to be done.
Okay.
And my hope is that I'll be finishing what the state has and getting that out in discovery within the next few weeks. Bodie is, I don't know where we stand on that as far as what to do next.
Judge,
Oh, you know what? We took the microphones out.
I see it now, but I thought you did that for me.
Well, it was just fortuitous.
McLaughlin myself, yeah.
Discovery motions on October 2nd. Just for today's purposes, you didn't ask me to have in Mr. Walsh.
No, there was a motion excusing his
Okay.
appearance that I allowed.
And so do you want him here on the 2nd?
I think we should put him down.
Thank you.
Yes.
You are unmuted.
Proceeding court is in session.
So before we start, there's something I do want to talk to council about at sidebar.
You are unmuted.
All right, so the charge conference, the first question I have is regarding I'll go through them in the order that I have them in my very rough draft, but there is no request of the lesser included offense of voluntary manslaughter to the second degree murder charge. Is that what the Commonwealth's intention is, not to request an instruction on voluntary manslaughter as a lesser included of the second degree murder?
I'm sorry. That's correct, John.
Okay. And Neither side has requested an instruction of a lesser included of OUI,
It's correct as well.
and the defense is not requesting that?
That's correct, Your Honor.
Okay. All right, so.
Wouldn't it be better if a leather holster could lock? With limited carry options, responsible gun owners know the frustrations that come with carrying a gun. Unlike leather that's flexible, Kydex and plastic holsters can often be rigid, uncomfortable, some commonly break, while others may even damage your valuable gun. However, Kydex is far superior to leather when it comes to securing your firearm, especially during quick, everyday movements or in that critical moment of confrontation. Imagine if we could fuse the tactical advantage of Kydex.
All right. So the first instruction, the request from the defense is that I split the charge, and it's written that way. I'm not going to split the charge. So the way it'll be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one that's requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury, the arguments of the lawyers and the judge's comments, function of the judge, functions of the lawyers. Verdict must be based on the evidence. I've incorporated some of what you've both included into that. I have language here that similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try and guess what may have been removed or why. I think that came from the defendant's request. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to the questions and exhibits are evidence, with a more robust instruction, but that's what I've added. And I do have a line about sympathy. Then I do the view. I should say right off the bat, I am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that and I'm fully within the law to do that. So I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the bias part of that. And we'll go through and you can tell me who's going to argue this for the defense. Okay, so we'll go through and we'll do each one. The limiting instructions, I give the defendant's bad acts instruction. I'll give a similar instruction on the digital evidence that I did during the trial, photographs and testimony with an emotional impact, humane practice, and as of today, hypothetical. I had hoped that both of you could suggest something. I said that this morning. Do either side have anything for me on hypotheticals?
I'm sorry, I don't, Your Honor. We're going to be getting back at a fairly early hour. I'm happy to look on it.
That's fine. I mean, I can do it, but I wanted to give you both the opportunity. Yeah, go ahead and do one and send it to me.
I'm happy to do that.
I'll have one to you by the end of the day.
Okay, thank you. All right. Opinion testimony, evaluation of exhibits, direct and indirect, and circumstantial evidence. So I received today defendant's request, a late request for the law allows both direct and indirect evidence, and there is no distinction to be given. A conviction, however, may not be based upon the piling of inference upon inference or on conjecture and speculation. I don't think that's exactly the language from the case law here that you've cited. There,
I actually quoted it, Your Honor.
so from which one? From Haunch or?
Haunch quotes McCormick, and McCormick takes the law from Dustin. There are
Yeah, so,
multiple cases that
right. And the language that is typically given on this piling that I haven't really seen in years is you should not pile inference upon inference until the pile gets so high that it tips over logically or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. I mean, I could give that old language. All right. That's, I haven't given that in years, but I'll give that part of it. And just to finish off that paragraph,
When the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that she is guilty beyond a reasonable doubt. Okay, so that rounds off that. All right. All right, so now we'll talk about the indictments and the lesser included. So the second degree murder instruction that was provided by the Commonwealth and the one provided by the defense are just a little bit different. So if you take what was provided, there's one section that the defense incorporates that I think is missing from the instruction, and I'm going by the SJC instructions. So when you get to the second element of second degree murder, the defendant intended to kill John O'Keefe, the second element, first prong. So the second element is that the defendant intended to kill John O'Keefe. As you can see, the second element has three sub-elements. I'm reading from the Commonwealth's proposed instructions, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill. Now here...
Have you ever heard of an economy being taxed into prosperity? I haven't. The United States has risen from the depths of recession. In 2016, Tennessee had a $2 billion surplus. How do they do that? They have no income tax. They have low sales tax. How do they do that?
The Laffer curve is about the most recognizable economics graph of modern.
I am going to insert, because if you go back to the SJC instructions, I think it is appropriate to go back to the instruction on deliberate premeditation, which is the second element of that, is the language that is offered here by the defendant, that the defendant consciously and purposefully intended to cause the death of John O'Keefe. So who's arguing this for the Commonwealth? So Ms. McLaughlin, does that make sense there?
Yes.
Okay, so I am going to put that in there. All right. And the defense has the language of accident there, but Mr. Yannetti, that really goes at the end. That goes, as you'll see if you look at the instruction on extreme atrocity or cruelty, where you have to go. So that'll go at the end. That will go after the third prong definition. Then I will include the language that I think the Commonwealth put in its request. It goes there. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have created a plain and strong likelihood. Then you have in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. You may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol or drugs. That goes there.
That's fine, Your Honor.
Okay, does that make sense to you too, Ms. McLaughlin? Okay. All right, do you want both the mental impairment or consumption of alcohol and drugs? Oh, do you want to just leave the whole generic sentence?
Yes.
Is there any objection from the Commonwealth on that?
I don't believe there's any evidence of mental impairment, but the Commonwealth has no strong objection.
All right, but there's no evidence of drugs either. So do you want it to just be alcohol?
I suggest that would be most in line with the evidence, just to have intoxication under alcohol.
All right, it makes sense to me, Ms. Giannetti, if we focus just on the alcohol, but if you wanted the mental impairment, I'd include all, but. All right, so I will think about this one tonight, okay? Okay, then manslaughter while operating a motor vehicle under the influence of liquor. So, Mr. Yannetti, you have included in the language, what does it mean to be under the influence of alcohol? That paragraph that starts after the third element. Yep.
I'm sorry, what's your page number? I'm just going through my. 9. I have it, yes. Sorry.
Right, so you have included, it means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. Where is that language from?
This particular portion of it, I thought was from the model instructions. If I'm wrong, then we're fine with model instructions on this issue.
All right, what does the Commonwealth say?
The Commonwealth's language comes from the model and jury instructions, I believe, from the most recent 2024 instruction on intoxication.
And that's not in the Commonwealth's request, correct? That sentence I just read?
On page 5, third paragraph, it's either a similar sentence or a
Yeah, it's a similar sentence, and I was just having both. It was, a person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. So we don't need both, Ms. Giannetti?
I agree.
So you had both, so I'm just not going to do that,
We're perfectly fine with
okay?
I grew up always on the bigger side as a kid. I was always slightly thicker, big boned. That really continued into adulthood.
Contrave is for adults struggling with obesity or who are overweight with a weight-related condition and should be used with diet and exercise.
Contrave really allowed me to stick to all of these great weight loss programs and plans because I wasn't being overpowered by my cravings. Contrave gave.
So under the second theory, so the Commonwealth is proposing the theory of the 0.08 or greater. The evidence supports that. I'm going to do that. So in the language from the Commonwealth, the fourth element, now then we talk about wanton and reckless. So for the fourth element, Ms. Giannetti, this is where your language. You have language for 5 that actually belongs in 4, I think. I'm just going to find it. On the foreseeability, I think that belongs under 4. And that's where I'll have it. Okay? Belongs at 4 instead of 5. Do you agree with that, Ms.
No, yes, that's fine.
Okay, do you agree with that, Ms. McLaughlin? It belongs under 5?
yes.
Okay. All right. So I'll keep it. I mean, it belongs under 4. I'll keep it at 4 and not have it at 5 where you put it, Ms. Giannetti, okay? All right. I am going to give the lesser included offense of involuntary manslaughter. So there's additional language that I have found helpful in other cases when I discuss the language and the cause of death. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. And then the next sentence is a defendant's act is the cause of death where in a natural and continuous sequence results in death and without which death would not have occurred. Okay, so those 2 sentences I find go better together, Ms. Giannetti. Is there any objection to that?
No, I understand.
Okay, any objection from the Commonwealth? So, Ms. Giannetti, you have in here a police officer's opinion about a driver's sobriety, like that testified to in this case. A police officer didn't testify as to the defendant's sobriety. So,
I think you're right.
so okay, so that paragraph that begins with that, we'll just cross that out.
I think that's fine.
Okay. In this same instruction, I have included in the paragraph, in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another. Some portion of the sentence that I'm going to think about tonight, I have, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol. Okay. Any objection from the Commonwealth on that?
No, Your Honor, that was requested by the Commonwealth. If you can consider it, please.
Yep. So that will be in that last paragraph of that offense, Mr. Minetti. Okay, then the lesser included offense, motor vehicle homicide, felony, OUI, liquor, and negligence. I'm going to give that. So I don't have anything because the defense didn't propose any lesser included. So I didn't see anything that was inappropriate about the Commonwealth's instruction, Ms. Giannetti. I've added, I think, one line that a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. It's obviously the law, right?
Right, that's the law of negligence, and I do understand the law of negligence.
Okay. All right, thank you. So leaving the scene of an accident resulting in death. So what the Commonwealth has provided is basically just the six elements with nothing further. They're pretty much 1 and 2 have already been defined for the jury many times at this point. 3, the defendant knowingly collided with John O'Keefe. I think that's self-evident. So, Ms. McLaughlin, why don't we start from here? Why did you just give me the 6 elements?
Your Honor, as you suggested, the first 2 have been defined extensively for the jury, and I believe the other 4 prongs are self-evident, and they don't need further instruction.
Yeah.
I think it would be sort of redundant or unnecessary to explain to a juror what failure to provide documentation of registration and things like that does not warrant additional instruction.
Do you think they need to listen to me any longer than necessary, Ms. Giannetti?
We're in complete agreement, maybe for the first time in this.
All right, so we'll just leave it. You've offered 6 2 pages or 3 pages of definitions, so we won't do that.
That's fine.
Okay. All right.
Watch what protein shakes do to your body.
This is a protein drink. You've got almond butter. Almonds have a peel that's a lectin-containing food. You've got pea protein. Oops, peas are one of the worst combinations of lectin-containing foods. And you've got, what else? Cinnamon. Oh, thank goodness. There's something good in here after all. Stay away from this. Read the label.
You probably notice there's a lot of alternatives to milk, often plant-based, but beware. Just because it came from a plant doesn't mean it's good for you. Oat milk is just...
Ms. McLaughlin, the use of a dangerous weapon, a motor vehicle, I agree that's an
All persons have any business before the Honorable Beverly Kennedy, Justice of the Norfolk Superior Court in the County of Norfolk. Draw near, give your attendance, and you shall be heard. State of the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed.
Good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. I don't know how many times I start in the morning by saying we appreciate your patience, but today is one of those days. Again, we appreciate your patience. You may notice that one of your fellow jurors is not sitting with us today. I can assure you that that is because of an issue that is just personal to that juror and has nothing to do with any concern of any of you. So please disregard that. Okay? I do have to ask you those 3 questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So now we're at the point of the trial where the lawyers get to do their closing arguments for you. I've given them each an hour to do so, and they both tell me that they want me to give a 5-minute warning. I just don't want you to think I'm scolding them when I give a 5-minute warning, so we'll let them do that. When I was a trial lawyer, I tried a lot of cases in this courtroom. The thing I liked least about the trial was just before I stood up to give my closing argument, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. So because of that, you have to put your notebooks away. All right, so if you just put your notebooks away and just listen, and though the closing arguments are not evidence, they're certainly a very important part of the case. And we've all seen how hard the lawyers have worked for this long period of time. And we've all noticed that you've paid great attention throughout the entire trial. I'd ask that you extend your courtesy to the closing arguments. And in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last. So we will hear now from Mr. Jackson.
Thank you, Your Honor. Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America, lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep them close. Offer them help. Offer them a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Read and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Read dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall, with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock you heard about in this trial. It was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data. Look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monatomic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie. And Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They've been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You can see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I'll draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John. He motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, you know, your girl's been texting me? A push, a punch, a fall, pull Chloe off his arm, and now it's done. What was that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. Wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted that I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed. 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, and just in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, the butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call. Didn't remember on cross-examination when I was asking, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion of the Commonwealth's experts, were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about to the Ford Edge. Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John, he walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turns to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You can see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Kenton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barros's description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention. And they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16, and he finally had to tell the truth, or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Lochran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Lochran, he never disclosed his name in a single report. He hid it. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Lochran. That's a scary prospect. I want to touch briefly on the additional physical evidence or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses. And all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. A magic hair means nothing. The DNA means nothing. And that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight, the taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces. And no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that we saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally Port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally Port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same? Or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Olaney, Michael Lang, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there, who were unaccounted for. Massachusetts state troopers were there, unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found about 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not stop and shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have, had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37, and see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara, unidentified troopers and Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. Because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but two thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rinchler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement, before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rinchler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-reviewed articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rinchler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands. the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat, talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object and went further by insulting her. He went further than insulting her and dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth. And I did that because that's what this case is about, top to bottom, tip to tail. It's about the truth, not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling. It's not a whim. It's unflinching. It's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you, not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that, which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies, the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
Thank you very much, Mr. Jackson. All right, Mr. Lally.
Thank you, Your Honor. I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nutt. He was trying to bag valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened, and the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Flamati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, oh my God, I hit him. Firefighter Katie McLaughlin was tasked by Firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant. The defendant said, I hit him, repeatedly. Firefighter McLaughlin asked for clarification. You did what? And the defendant repeated, I hit him. Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him? Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, I hit him. You heard testimony from Officer Saraf, statements that he attributed to the defendant as saying that morning, this is all my fault. This is all my fault. I did this. This is what the defendant is saying on scene. Since then, stories changed a little bit. But those were the words that came from the defendant's mouth on January 29, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case. Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a 3-card monitoring. Facts and the evidence in this case are your card, they're the Queen of Hearts. And so what I want you to, or what the defense wants you to do is not look at that card. Look at anything else. Look at movement, look at this person, look at that person, look at text messages, look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the 3 indictments before this court. The evidence and the facts of this case are for you, the jury, to decide. Using your common sense, using your life experiences as your guide through that as you go. Before I turn to that evidence that I will submit to you and ineluctably demonstrates the defendant's guilt, let me first just address Trooper Proctor. The text messages from Trooper Proctor are unprofessional, they're indefensible, they're inexcusable. However, as distasteful as those messages are, and their content is, I submit they have no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation that the Massachusetts State Police collectively conducted into John O'Keefe's death. As was asked of Trooper Proctor on cross-examination, these were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom, put to him in sort of a safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy, of any framing of the defendant, of any planting of any evidence, no evidence whatsoever. Why? Because it didn't happen. There is no conspiracy, there is no cover-up, there is no evidence of any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. 2 things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional. There's no defense to them. And the defendant killed John O'Keefe. Turning to the evidence, let me first talk a little bit about John O'Keefe. You heard a lot about him over the course of this trial, about his selfless story, from his family and friends that loved him, including his adopted niece and nephew. You heard a lot about the lives he touched and the different people who he had friendships with. You heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a timeline. It's going to be a little hard to see up here. What I'm going to go is from left to right. January 28th, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:25 p.m. in the afternoon, the defendant texts Mr. O'Keefe, "Tell me if you are interested in someone else. Can't think of any other reason you've been like this." John texts back, "Nope." 2:25, Mr. O'Keefe texts the defendant, "Things haven't been great between us for a while. Ever consider that?" This is also testimony that you heard through multiple sources, whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, "Sick of always arguing and fighting. It's been weekly for several months now." He then texts the defendant, "OMG, stop calling." This is during the time frame that Trooper Garino was talking about, with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon, as she's continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m. The defendant texts John, "So you're not into this anymore." 2:34 p.m. John texts the defendant, "I am not answering, stop calling." The defendant then texts John, "Then stop starting with it." 2:38 p.m. The defendant texts John, "I'm going to grab a drink in a bit." 2:38 in the afternoon. Around 3 p.m. is the testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul, asking him to go out for a drink. This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point at which the defendant says to Ms. O'Keefe, "Wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's, with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda, tall cylinder glass, lime, and a straw. 9:13 p.m., drink number 2. 9:20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. Drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall. There's several individuals at the waterfall testify that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, keeping understanding that some of these drinks are not the full tall cylinder drinks, what she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, about an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Polakifis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, "Where to?" 12:14 a.m., based on the fact that she's driving, and Ma'am McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe, speaks with him regarding directions, sort of going over which way to come in, Chapman Street, over Cedar Crest, as far as coming into Fairview Road. 12:15:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17:56, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to it coinciding with what you observed the black SUV from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a 3-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time, at 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxon, and Ricky D'Antonio, pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone in that area between 32, 34 Fairview Road, where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Ms. Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. What you have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. Movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, moving up, moving up, as witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota tech stream, which you now have up on the screen before you here, indicating that following that 3-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, with 24.2 miles per hour for 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event 8 minutes after the 3-point turn when the vehicle is in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at 1 Meadows Avenue, Mr. O'Keefe's home. 12:37 is when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42, Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. If you recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55, the defendant texts John, "See you later." 12:59, the defendant calls, leaves another voicemail from Mr. O'Keefe. Exhibit 637, it sounded like this.
"John, I'm here with your fucking kids. Nobody knows what the fuck you are, you fucking pervert."
But somebody didn't know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there, she had struck him there, she had left him to die there. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point. 1:10 a.m., the defendant calls her parents. 1:11 a.m., she calls Mr. O'Keefe and leaves this voicemail.
"John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. He's sleeping next to me. You're a fucking loser. Fuck yourself."
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. So the calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's needs, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe, where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a plow. 5:07 a.m., the defendant leaves One Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Perry Roberts. Ms. Roberts starts calling hospitals, calling KPD, calling 911, something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent, and calling your parents, and all of these other things. No calls to 911 from the defendant. While John O'Keefe is laying, freezing, and dying from brain injury and a skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., the defendant's vehicle is seen on the Canton Library camera heading towards the waterfall. Seems to be sort of retracing steps. 5:18 a.m., the defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35 is when the defendant arrives at Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken taillight at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because she knew exactly where he was. She had hit him and left him there the night before. She had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives at Ms. McCabe's house. 5:33 is when the defendant, Ms. McCabe, and Ms. Roberts return to One Meadows Ave searching for John. 6:03 is when the defendant, no one else, spots Mr. O'Keefe's body buried in the snow. Exhibit 12, indicating this cruiser camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spotlight that Officer Sarah had to use in order to locate, even with a vehicle of Ms. Roberts parked right in the middle of the road. In the darkness, in the snow, in the blizzard, in those conditions, the defendant, sitting in the back seat of the vehicle, knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. The defendant knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to Mr. O'Keefe's phone. 6:23 and 6:24 in the morning is when Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search of evidence. 5:30 p.m. is when the defendant's vehicle arrives at the Canton Police Department south. We circle back for a moment to Mr. O'Keefe, to his family, to his friends, and to his relationship with the defendant. We heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. We heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Ms. that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. He even blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him. Invited her to sit down with him while he explained to their nephew Patrick about John's passing. Defendant shows up at the house. Abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning, grieving with the family. She left with a bag of her belongings, drove with her family there, and then took an extra vehicle in the height of the blizzard, around 1 o'clock in the afternoon, drive that vehicle all the way from Canton, where it was parked at her boyfriend's house, where she stayed over on many occasions, drove that vehicle, or felt the need to drive that vehicle from Canton all the way down to her parents' house in Dighton at the height of the blizzard. You heard testimony from Aaron O'Keefe of the text messages and the phone call on January 28th. You heard that Erin O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Erin O'Keefe as to what's going on with John. Erin O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. Defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dayton. She's indicating over the phone to Erin O'Keefe, "I don't think I'll ever see you guys." Why? If she didn't kill John, why would she say that? You heard a lot of testimony about New Year's Eve in Aruba. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Erin via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met, meaning the defendant, Mr. O'Keefe, got into an argument about it, and she and Erin O'Keefe never ended up meeting up in Aruba. Her testimony consisted from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child. The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony about 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out, and then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off from Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asks him if he's okay, asks him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. And I know this is a displeasure to the defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece, Kaylee, John tried to diffuse, tried to walk away, and the defendant would fall each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to see if McCarthy's eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have testimony in regard to the ring camera. Kaylee indicated in her testimony that John had had that for about a year. So during the course of 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code for the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with her father, upstairs in the home. Neither of those devices had access to the ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots. Mr. Higgins and Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, in which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video. A variety of stories that the defendant tells on the morning of January 29th. There were text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call Julie Albert, because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, this is a phone call to both Mr. Albert and Ms. McCabe testified was never answered. As the phone is ringing, her husband Matthew McCabe reminds her that they saw the defendant and Mr. O'Keefe and the car outside of 34 Fairview. So she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a plow and that he's dead. And then indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked taillight before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he has some concerns about them driving around in a vehicle with a damaged taillight in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken taillight in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in the photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage when the search warrant is executed on February 1st. You have the text messages between the defendant and Lord Sullivan from January 29th, in which the defendant indicates to Lord Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by the defendant, Ms. McCabe, and Ms. Roberts, around 6 a.m. 5 a.m. would be about an hour before. 5 a.m. would be between that time of where the defendant is unaccounted for, heading in the direction of 34 Fairview Road, 5:18 and 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitford as to SQLite databases, P-list databases, Knowledge C databases, state DB tabs, as far as all of them, also from Trooper Marino as well. These searches were unequivocally done at 6:23, 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not deleted by a user. That is not what deleted means. Frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Cellbrite, and by Cellbrite, the person who designed that being Mr. Whitford, had to alter exactly how their software worked because of people like Mr. Green misinterpreting the data as he did in this case. And what did Mr. Green say? Yes. But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance, if you recall those. She asked firefighter Whitley how long to die in the cold without a jacket. She knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, back of the same ambulance as firefighter Whitley. You have testimony from firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have in the testimony from firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time. What each of those first responders indicate is that the defendant repeatedly stated, is he dead? Is he dead? Not, is he okay? Is he going to be okay? How is he? Any sort of questions about the medical condition. Is he dead? That phraseology repeated over and over again. And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 5:18, 5:35. The repeated questioning, firefighter Whitney, firefighter Woodbury, asking Ms. McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for. When she asks over and over again, is he dead? Is he dead? Is he dead? You have the testimony that you heard from Ms. McCabe and Ms. Roberts. I say them together because as far as these two women were concerned, they did not know each other really at all. The only time, as they both testified to, that they ever spent appreciably together prior to January 29, 2022, is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at a Reebok's outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece, and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th. As Ms. McCabe testified, John was my friend. I love John. He was an amazing guy. At the waterfall, Mr. Alberts said going home to have a drink with his son, Brian Jr., if anyone wants to come. Open invitation to the table. She said to Mr. O'Keefe and the defendant, you guys should come. Both the defendant and the victim indicated that they wanted to come and that they were. She describes the phone calls and the text messages that she receives from Mr. O'Keefe, that she's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down Chapman, she's going down Fairview coming off of Chapman. But you first go down a big steep hill. It flattens out for a little bit, and then you go down a second. 2 hills going down on Chapman. Matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is reporting that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe. She's still trying to provide directions to Fairview because Mr. O'Keefe has never been there before, and neither has the defendant, which is further corroborated in Trooper Guarino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction. But she's giving directions, and she indicates that she uses a house that Mr. O'Keefe will be familiar with, that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time, a long time ago. However, in the defendant's mind, it's so prescient on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Ms. Roberts and Ms. McCabe in Ms. Roberts' car. She's still talking about it at that time. It's that much on her mind. Ms. McCabe indicated that she looked out and she saw a vehicle initially in front of the front door as Mr. McCabe, as Brian Albert Jr., as Julie Nagel, as Brian Nagel, and the vehicle moved up several times, several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Ms. McCabe and Ms. Roberts, and then moves up further beyond that. I say that in the sense that it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece, Kaylee, at 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, Jen. John didn't come home, got in a fight, left him at the waterfall. The variations, different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, we saw you outside of my sister's house. Then she starts yelling, Jen, did I hit him? Could I hit him? Then they start discussing, or the defendant brings up her cracked tail. Then both Ms. McCabe and Mr. McCabe hear the defendant screaming outside of their home at about 5 o'clock in the morning, or shortly after 5 o'clock. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicates, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule, pretty strict rule in his house as far as you take your shoes off when you come in the house. So what did Ms. McCabe and Ms. Roberts both do when they're entering in that house on January 29th? They take off their boots, they get out in the snow, they take off their boots in the mudroom, and then they walk in. What did they both indicate that the defendant did that morning when she came back to the house? Walked right in with the shoes. You hear that second voicemail. It's after the defendants arrived back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that strict rule? Because she knows where he is. She knows it's not an issue, he's not coming home because she hit him with her SUV, that she left him in the snow. Ms. Roberts and Ms. McCabe are frantically sort of running around the house looking for Mr. O'Keefe. Defendant's not. They then get in the vehicle. They drive back towards Fairview Road. And again, the defendant from the backseat of the vehicle immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight over to where Mr. O'Keefe is laying on the front lawn. We have the testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up, and you recall several witnesses testifying about that, pick him up on scoop stretcher and then bring him over to the ambulance while they're conducting resuscitative efforts trying to save Mr. O'Keefe's life. But Ms. Roberts indicated that she observed underneath only the phone on the grass in the area that is completely covered in snow in every other area except under Mr. O'Keefe. So I would submit indicates how long Mr. O'Keefe has been there. Now recall, around 12 o'clock or so is when it starts to snow and it starts to stick a little bit. You heard all that testimony. And I know it was a lot of testimony about snow, a lot of testimony about weather, but there's a purpose to that. There's a point to that, okay? As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, Ms. Roberts observed some 6 hours later after it starts snowing, it's still visible only under Mr. O'Keefe where his body is. So I would submit as evidence to you as to how long he's been there. Now, on top of that, you also have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose to that as well. If you look at those, if you look at the video of the defendant crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which even Dr. Wolf would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video and the stills, you can see the damage consistent with the taillight at each and every point. You see the damage consistent with the taillight from the 507 video. You see the damage consistent from the 822 video from Lieutenant Ray from the cruiser camera video when he's pulling into the driveway. You see the damage consistent from the Dighton video at the defendant's home. You see the damage consistent from the right here, February 1st, 2022, when the search warrant is conducted, Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. The magic hair, as Mr. Jackson likes to call it. So the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because the vehicle looked like that on the left when it was caked in snow, when Officer Barrow saw it in the driveway in Dighton as they were wading through 1.5 feet of snow, walking up. Because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like. What you can see, however, is the damage to the taillight, to the side of that taillight, consistent with it. So that hair, that 7/8 of an inch hair, was frozen to the side. And as you remember, the testimony from Sergeant Buchanan about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes, after it's been in there from January 29th at about 5:30 p.m. until February 1st when they conduct the search warrant, the hair isn't still frozen as it's contained within heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted, as you can see from left to right. The weather, also important, I would submit. Weather was wet. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. You heard all that medical testimony in relation to it, and you heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out, Mr. O'Keefe is out there in just a shirt and jeans. Now, you heard also testimony from Ms. Roberts in relation to the injuries she observed from Mr. O'Keefe. That's initially on scene. There was one eye that was swollen, not the other. That's indication of the swelling that Dr. Scortibello was testifying to with no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing at the Good Samaritan. Submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony, to medical testimony, to forensic testimony, to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Saraf's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Saraf. You have the testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mullaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body. There's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a funeral for another police officer, for another department, who they didn't even know. Traveled all the way down to New York and then came back before the blizzard, only to come back from that to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn? Really? That's the conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak, but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before, they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments, incessant phone calls, and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to C.F. McCarthy's around 9 p.m., started drinking vodka sodas, the men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the side, same side as Waterfall. Same testimony that you heard from Ms. O'Keefe, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger's. She said they were left the Waterfall, were invited to her residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night." June 2022, you have that other reporting of that other version that she now has evolved into as far as stating to Sergeant Buchanan, "Are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked." What evidence do you have of that? Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never went in the house from the testimony and the data points that you have from Trooper Green. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian Albert, Nicole Albert, Brian Higgins, all indicated in the testimony, and the defendant knew, based on our questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the Waterfall. The weather was a weapon. You have the testimony about the car, the defendant's car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxson. Ms. Maxson indicated she saw a male passenger, female operator as the vehicle was turned. Remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse, a 3-point turn on Cedar Crest, is then taking a right on Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxson are taking a left on Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxson can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. And I asked him, what happened when you open the door? What happens when you open the door to a vehicle? Dome light comes on. So there's reason I would submit, or the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle. And then they're gone. The Nagels, Brian Nagel, Ricky D'Antonio, and Heather Maxson drive away from that. We have the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house where everybody's attention is drawn, Ms. McCabe is turned around facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road. Ms. Levinson is looking back at Ms. Nagel away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning. The testimony recalled when you have text messages in regard to Colin Albert when he gets picked up.
Mr. Lally, 5 minutes.
Yes, Colin Albert, Miss Allison McCabe, Brian Albert, Cole Albert, Caitlin Albert, Brian Jr., all indicating that he was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the Waterfall in the first place, as far as John O'Keefe and his nephew coming in early in the day, getting a couple slices of pizza, what are you doing later on, contained within those texts. You have testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic about those items being recovered. And in particular, the items being recovered on January 29th by that search. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level, 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I would submit is consistent, from firefighter Formati to Dr. Rice. We heard testimony regarding the defendant's blood alcohol concentration from Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. We heard Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall. You have the witness testimony in the surveillance video in regard to the forensic testimony that you have. In regard to the medical testimony, you have the sort of pattern abrasions, clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone at any point in time ever said that Mr. O'Keefe's arm was out like this at the time that he struck him, and he did a pirouette and then flew 30 feet in the air. 12 inches of abrasions that the doctors were, the biomechanical people were talking about yesterday. 12 inches and then 6 inches to the tail end is easily solved by this. And the dimples on his arm are, that I would submit, are consistent with the dimples on the tail light cover piece, are right around this area of the elbow. We have testimony in regard to forensics as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that tail light house, on the house. His DNA is there to the exclusion as well of Sergeant Mechanic and Chief Prop. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA and only Mr. O'Keefe's DNA is on his clothing and his fingernails, consistent with Dr. Sportybello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing. You have testimony from Ms. Hartman, Trooper Paul, as regard to the damage that they observed, the dent, scratches, 7/8 of an inch hair. You have the testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Lear and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally, wrap it up.
Yes. All consistent with pieces of taillight that are found within his clothing. Ms. Gilman, if I could. 605, this is what this vehicle looks like backing up at that speed for approximately that distance. There's another, years and years ago, started practicing in Norfolk County. Braintree was now Quincy. I eventually became a far smarter man than myself. Eventually became president of the United States. His name was John Adams. John Adams once wrote, "Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I clearly have one sentence.
1 sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates their guilt on each of the indictments before you, and I would ask that you find this. Thank you.
All right, thank you. Jurors, I have my instructions on the law I'm going to give you. My guess is it's probably about an hour. I'd like to start it now, but does anybody need a short break? You can take a short break. Okay, we'll come back in 5 minutes.
You are muted.
Hey there, Karen Reed, trial watchers. You know what a lot of the trials we cover remind me? It's that you got to be careful who you surround yourself with, who you let into your life. Do you really know? I mean, it's a scary thing to think about. Well, that's why I'm so thrilled to talk to you about the sponsor of this week's Law and Crime Trial stream, truthfinder.com. Honestly, with our content, I really can't think of a better service that can provide actual safety for you guys. Why do I say that? I say that because Truthfinder is one of the largest public records search services in the United States. Their whole goal is to help people like you learn about the people in their lives. And here's how it works. You go on their website, truthfinder.com, and you type in a name. For instance, your new neighbor. Let's say your new neighbor is me, Jesse Weber. Make it easy. You type in my name, and within minutes and a paid subscription purchase, you can access unlimited reports that could include information like phone numbers, location history, criminal and traffic records, including possible arrests and criminal convictions. Goes without saying, but I don't have any of those. Truthfinder has been partnering with Law and Crime for a while now. We actually use it to research some of the cases that we've been covering. But in general, it can help provide peace of mind when you do these unlimited public records searches. Also, you know what's really useful? From within that report, you can search an address to see registered sex offenders that may live in that area too. That's the point. Unless you use Truthfinder, you may never know the reality about the people around you. Also, Truthfinder is just an incredible resource to use when reconnecting with people like long-lost friends, family members you haven't spoken to in a while. You can use Truthfinder to help track down these people's information. It's just a great tool. Now, here's the kicker. Right now, you can get 50% off of your first month of confidential background reports. Just go to truthfinder.com/else.
Instead, it is up to the Commonwealth to prove the verdict in this case. But yes.
Thank you. You see both there.
All right, jurors. Thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purposes of reaching a verdict in this case. But before you do that, it's my responsibility to give you instructions concerning the law. The instructions are divided into three parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part 1 of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. I will explain reasonable doubt in just a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged, or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you, and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions, and the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law to that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with other jurors. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider three questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted test or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limiting instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reed had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were in fact John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and or the defendant. If you do not find it is more likely true than not that John O'Keefe, Karen Reed, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic and pleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can infer from the evidence that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witness testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of these witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the assumed facts are true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. Now, you have the same powers with respect to the exhibits that you have and the testimony of the witnesses. Look them over and decide the weight, that is the value they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it is written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what the exhibit purports to show and how much weight, if any, you give each exhibit. Now, you've heard me talk about the sources of evidence in this case. Those are the tools that we have to decide the case. Now, with the evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference, reasonable, and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household, a child, roommate, or spouse, hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I have just described. You may have noticed that the defendant did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that the defendant did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. All right, that completes my first part of the instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, You must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. You'll have both these choices on the verdict slip. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely, by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point. Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element. Here, the defendant must have intended her acts in the sense that they were not accidental, but it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition and how well the defendant could see and could control the vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. Save a little time for you. Right? As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Now that completes the second part of my instructions. I will now turn to the final instructions. In order for a jury to return a verdict, that is to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are still 14 of you. To avoid the need for a new trial, if one or more jurors becomes ill or has to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. However, when you begin your deliberations, the law of Massachusetts is that there can only be 12 jurors. Therefore, at the conclusions of my instruction, the clerk will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted because, as I've indicated, it is important that we have extra jurors in the case of emergency. If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused, we would have to try the case all over again with a new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start their deliberations all over again from the very beginning. Therefore, it is important that the alternates not discuss the case with anyone, including each other, for if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not influenced by anyone else. Now, different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own foreperson. In Massachusetts, the judge is responsible for selecting a foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations, however, in that sense is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400. Would you be our foreperson, please, sir? Thank you. When you return to the jury room to deliberate, the court officers will deliver to you all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not consciously aware of them, and I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to see counsel before we reduce your number to 12.
You are unmuted.
All right, so Mr. Clerk, will you choose the alternates, please?
Could the juror sitting in seat number 3, who is juror 79, step down and take your place as an alternate? And the juror sitting in seat number 2, juror 14.
All right, so ladies and gentlemen, we need to swear in the court officers. They're going to be in charge of you during your deliberations. I suggest that you listen to the oath that they are taking so that you can be aware of their responsibilities. Now you can swear them, Mr. Clerk.
You swear that you will keep this jury and alternates in some separate bucket meeting place until they agree, that you're not suffering any person to speak to them, or speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they discharge their verdict, except by further order of the court, so help you God. Thank you.
All right, so jurors, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you have heard here in the court during trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may now retire and deliberate your verdict.
Jurors, this time taking your notebooks. All rise, follow me. All rise.
May be seated.
All right, so counsel, I'll give you a few minutes to work with Mr. McDermott on the verdict slip, and then I'll come back out.
Thank you, Your Honor.
All rise for the court, please.
So involuntary is that?
No, involuntary.
Hey there, Karen.